Welcome to the United States Court of Appeals for the Fourth Circuit. We have four cases on for hearing this morning. First up, 23-2069, Alfaro Zelaya versus Bondi. Mr. Sangueza, or Miss, sorry, my apologies.
Good morning, Your Honors, and may it please the Court. My name is Edith Sangueza. I'm an attorney from the Center for Gender and Refugee Studies, appearing pro bono for petitioners Ms. Alfaro Zelaya and her daughter. With my colleague Ann Peterson, I'm prepared to discuss the issue of nexus as to asylum and withholding. Ms. Peterson will be addressing the Convention Against Torture. No woman says no to me. Those are the words from the persecutor's mouth. That's why Ms. Alfaro Zelaya's persecutor, Roberto, harassed, stalked, attempted to kidnap her, threatened to kill her and her son, and dismember her daughter. The board's decision denying asylum and withholding comes down to the issue of nexus. So on asylum and withholding, that's really the only issue before this court. And under this statute and this court's precedent, that standard is clear and it's uniform. The petitioner must show at least one central reason for their persecution has to be because of a protected ground. The question the agency must have asked is why Roberto targeted Ms. Alfaro Zelaya and not another person for persecution. And on this record, Roberto's own words and actions show that he targeted Ms. Alfaro Zelaya because of her sex and his view, consistent with country conditions evidence about Honduran culture and society, that Honduran women had to submit to him. But despite these words...
So what's the evidence of that he said that, or there otherwise evidence in the record to say what you just stated?
Yes, Your Honor. So on page 180 of the joint appendix, he said, "No woman says no to me."
Well, that's a generic statement about women, not Honduran women.
Your Honor, I think if you combine it with the country conditions evidence about Honduran women, which the agency has to consider the full factual context under Alvarez-Lagos, there are many sites about a culture of machismo, a culture of violence against women, that there are...
Well, that may be, and that's quite unfortunate. I don't necessarily disagree with you, but how is that tied into his particular obsession with this particular woman?
Because it's because, he's telling her that he has the right to her body, basically, and the right to control her.
Sure. I mean, clearly he said that, but that he could have said that to any woman. Could have said that to a French woman, to an American woman. Is it the fact that he just happened to be, they happen to be in Honduras, and that's enough? If so, it would seem to me that every Honduran woman who was the victim of an obsessive man, and again, I'm not condoning that, would have a valid claim for asylum, but that's not the law, is it?
Well, Your Honor, I disagree.
Is it? Is that the law?
That any Honduran woman? No, Your Honor,
Okay.
That's not the law. But I'd like to go back to...
But the law, the way the law is written, it is not an open-ended statute. It is designed to grant asylum to very particular groups, and not just to anyone. And that's why you have a nexus requirement, and that's why you have these particular groups listed, and it's just very particularized. And there are, unfortunately, men all over the world who offers, make sexual overtures or attempt sexual advances, and they are rejected, and then they become angry about it and obsessive, and that's a very unfortunate thing. It's regrettable that happens, but it's a worldwide phenomenon, and the busting up of romantic relationships and rejections of sexual advances and overtures. As I say, it's terribly unfortunate, but unfortunately for you, the statute is written in a particularized way, and what you're talking about is a universal phenomenon, which would be as broad as all outdoors. As my good colleague, the chief, says, this is not particular to Honduras. It could have happened anytime, at any place.
Your Honor, I think I have 2 points on that. So first, the cognizability of the particular social groups of Honduran women and unmarried Honduran mothers, the board didn't decide on those. They assumed they were cognizable for the purposes of their decision. So their decision is about nexus. So I think the cognizability of the particular social groups is to the side. But I do think on the statute, for example, race and religion, those are extremely broad categories, right? There are billions of Christians in this world, but someone can prove asylum on the basis of their Christianity if they prove the other elements of the asylum claim.
We have not spoken to the extent in the immigration context on how gender factors in the persecution. Title VII is an area in which we have directly spoken on it. And to what extent should we look to Title VII, since we have nothing here, which in essence presumes the harassment of a person on the opposite sex is presumptively on behalf of the gender or the sex of the person. That is an indication of a nexus type analogy in the Title VII area that we could, I think we could, but what is your perspective on that?
Yes, Your Honor, I agree. And I think, as Your Honor said, Title VII has that because of or on account of a similar nexus standard. So for example, if a male employer is harassing his female subordinate because he wants to have sex with her, he couldn't say, oh, that's not sexual harassment. It's just that one particular lady that I like, right? That is definitively sexual harassment. And so I think that is kind of similar to the situation here, where he says directly to her, no woman says no to me.
Is it a factual determination or is it a legal determination?
On the issue of nexus. So I think there's 2 issues here with the nexus. So first, the board's decision isn't supported by substantial evidence. And in fact, I think substantial evidence on this record compels a finding of nexus to the assumed cognizable particular social group of Honduran women, unmarried single mothers. And that's so because of his words to her, no woman says no to me, which has to be viewed in the context of women are systematically mistreated, disenfranchised. Violence against them is not even recognized by the judicial system.
So does it matter that petition is a Honduran woman, or is it because she's a woman?
So it's Honduran women, and I think like the issue of his sexual romantic interest in her, that's part of the nexus to Honduran women. The fact that he feels entitled to her and that he feels entitled to do this harm against her is because it's in the context of Honduran women. And I think, Your Honor, Judge Diaz, to your point, I mean, he wouldn't do this to a tourist French or American woman in Honduras because it's Honduran women who are subjugated.
Well, that is not clear. I mean, he does. She lives in Honduras, but that doesn't automatically make it that particularized. I think maybe the same concern has been expressed by my other colleagues, but it just seems to me that there are other avenues to correct this kind of behavior, including a criminal prosecution if someone oversteps the proper bounds and visits violence or whatever, or maybe a Title VII prosecution which just asks whether there's sexual discrimination on the part of someone or what have you, or maybe a civil tort for assault and battery or whatever. I mean, there seem to be a lot of other vehicles for this under civil law and under under, under criminal law, if the bounds are overstepped here, but, you know, asylum is not an omnibus statute, and it's not a backup in case other, what I'm saying is, other forms of litigation and other vehicles for bringing this complaint seems to exist, and the fact that you didn't choose one of those doesn't mean that, that the asylum statutes are sort of omnibus backups.
Your Honor, if I may speak to that. So I think the Hermansdorfer Declaration, which is in the record, which was not considered by the agency, for example, Joint Appendix 2033, she is a Honduran attorney. She's talking about the police, the judiciary, and explains that, like, all those institutions in Honduras are completely ineffective and don't protect women.
But couldn't you bring a civil action for assault and battery?
I think the record, the country conditions evidence says, no, you can't do that in Honduras. That's not an effective means of protection, and the police don't take.
Does the record bear that out?
Yes, Your Honor. The country conditions evidence bears that out.
Did you try to file a complaint of some sort or against this individual if he's, you know, if he's obsessive or some kind of monster? And I don't know, he may well be. There are just all sorts of correctives in the law, but to the asylum statute doesn't seem to fit here, simply because of the universality of this unfortunate form of too often masculine behavior.
Your Honor, are you talking about a legal action in Honduras?
I'm talking about an action anywhere.
So given that this happened in Honduras and he's under the jurisdiction in Honduras, I'm not able to bring an action in there. And so, yes, so for the purposes of here, I think we're just talking about asylum and withholding.
But more importantly, it seems the record does indicate that the IJ, neither the IJ nor the BIA considered the country condition evidence. And that goes to the heart of maybe what Judge Wilkinson's addressed, you know. Yeah, if you can get the police or someone to help you, yes, that's an avenue. But that's not an avenue, at least under this record. At least it's a factual question as to whether it is. It's not an avenue. If she could do that, yes. But she's not in the United States down in Honduras. She's in a different country with different conditions, and I don't see where the IJ nor the BIA considered that evidence. That alone seems to be a ground to remand the case for the consideration of that.
I agree, Your Honor. That's correct. The agency never even discussed the country conditions evidence, and Alvarez-Lagos says that the agency must consider the facts holistically with an eye to the full factual record. They didn't do this here. So here, his words, his actions, the fact that this was based on, first, a sexual romantic interest. I see my time has expired.
You can
May I
answer.
finish?
You can
Okay,
answer.
that this was based on a sexual romantic interest, which has a connection to sex, as well as the country conditions evidence. I think that compels a finding of nexus to these particular social groups defined by sex. And at the very least, it was legal error that the court didn't, the agency, didn't ask the right question of why her and not another person targeted.
Ms. Sangueza, before you sit down, so two questions. This argument about the agency not considering country conditions, was that made with respect to both the asylum claim and the CAT claim, or just the latter?
Yes, Your Honor, to both the asylum claim and the CAT claim. In our opening brief, pages 36 to 38, we talked about some of the country conditions evidence in the record and how that supports a finding of nexus.
And then the second question is, you've said this twice, that the country conditions evidence coupled with the statements that this individual made to your client compels the conclusion that the reason why he was pursuing her was because she fell within one of the social groups that we assume is correct for purposes of this appeal. there's a difference between being compelled to one result and one result only, and having persuasive evidence that might lead a fact finder to one of two reasonable results. Why does this evidence compel that result?
I find that it compels this result because here the agency's own factual findings refute the conclusion. The things he said to her, like, no woman, you're not allowed to behave this way. That's similar to in Chicas Machado, where this court found a nexus to religion, where the gang was extorting the petitioner because they thought that since she was a Christian, went to church, she could be a good lookout for her. And they said, because you're a Christian.
But that's a classic protected social group, but you said yourself, it's not enough that she was a woman. It has to be that the reason he pursued her and was obsessed over her was because she was an first of all, a Honduran woman, and the second category was a single mother. So what's the evidence other than the country conditions? Is that it?
So, I mean, it's the
There's nothing from his mouth, right, from the assailant's mouth, that leads you to that conclusion standing alone, does it?
I think the fact that they're both Honduran, they're in this society, and I think also her past.
You think that's enough without the country conditions?
I think you have to consider the country conditions under Alvarez-Lagos, Your Honor. And I think also her own past experiences of being horribly beaten by past partners, like her own lived experience of past violence, that's at least relevant, and that it corroborates the country conditions about this. And as for the single mother piece, in Alvarez-Lagos, this court said that gendered threats like calling the petitioner a whore, which is similar to him using objectifying language like calling her a doll, the threats to kill the Alvarez-Lagos petitioner's daughter, that's the same situation here. Like there is a nexus to her status as a mother, as in Alvarez-Lagos, Your Honor.
All right. Thank you very much.
Thank you.
Ms.
Good morning. Good morning, Your Honors. May it please the court, Ann Peterson, and I'll be discussing the Convention Against Torture piece with you this morning. The agency here made two central errors in its Convention Against Torture claim. Judge Diaz, you just pointed out one of our arguments, which is that it abused its discretion when it focused solely on the police report, on the existence of a police report, and disregarded all of the evidence that proves the Honduran government acquiesced to her torture. Second, it imposed an unlawful reporting requirement that is at odds with this court's precedents.
One problem with your acquiescence claim is that, you didn't give the government any kind of chance to address what you're complaining about. You were going to file a police report, and then you actually fled Honduras one week later without ever returning to law enforcement. And so how can it be said that they acquiesced in anything when you never filed a report? You say you were going to, and then you took off.
That goes to my second point, Your Honor, and so I'll just skip over to that, which is that reporting is not required. But also I would point out a factual distinction, just clarification. She did file a report, and the police permitted her to file a report, but that's all they did. That's where the assistant stopped. They did not investigate her persecutor. They did not arrest her persecutor. They did not prosecute her persecutor. And in fact, he was allowed to remain free, and he attacked her within hours or days. And then he continued to stalk her. And when she called the police, they didn't even answer the phone. So she was not required, under this court's precedent, to wait in danger and continue making futile outreach to authorities who wouldn't help her.
Too often we're saying because government didn't solve a particular crime or didn't resolve a particular crime, that's acquiescence. But that happens all the time in the United States and in every country. There are criminal acts that take place, and because of an absence of evidence or one reason or another, unfortunately, the crimes are never completely solved. But that doesn't mean that every government failure to properly resolve some sort of possible criminal action is acquiescence. And I wonder whether, again, you've given them any kind of fair chance when you said you were gonna report this thing and then you fled. You left the country 1 week later.
She did report it, Your Honor, and that was where the assistance ended, and she identified her torturer. So they had a lead, and they didn't follow it. They did nothing. They offered her no protection, and then she was attacked again, and stalked again, and attacked again. And under this court's precedent, she's not required to persist in reporting if it would be futile, which it was, or if it would put her in greater danger, which it did. And I realize that I only have a few minutes, or a
Well,
few
you're
seconds.
actually over your time, but I'll give you some.
Oh, so apologies, Your Honor.
Very
I will
quickly.
just say in closing that just to the point about disregarding the country conditions evidence, not in neither decision does the agent even mention the country conditions evidence. And the country conditions evidence alone demonstrates acquiescence with an over 90% rate of impunity for femicide and violence against women. So we would ask that the court find that the evidence demonstrates acquiescence, or at a minimum remand for consideration of the totality of the evidence under the correct legal standards.
In the case of the acquiescence here, this is so different from those cases where we have found the possibility of acquiescence. And the government points to the Orellana case where the petitioner was rebuffed in her vast number of phone calls that were made to law enforcement over a 12-year period. And nothing like those circumstances are present here. Nothing.
That is a unique scenario and really a horrifying one. But I would also note that in Orellana, she received some assistance. At one point, she was given a protective order and it proved to be ineffective. But in this case, zero assistance was given. And in other cases, like in Portillo and in Perez Morales, this court has reiterated that reporting is not required should it be futile or place the petitioner in greater danger, as it did in this case. And if there's nothing further, then I will save the rest of our time for rebuttal. Thank you, Your Honors.
Thank you, Ms. Peterson. Mr. George?
May it please the court, Matthew George for the Attorney General. I'd like to reiterate the factual scenario that's going on in this case and what petitioner herself has identified as the motivation for why Roberto took the actions that he did against her. She over and over said it's because she rejected him. She said that in her credible fear interview, she said that in her asylum application, and she said that in her testimony. Now, in her testimony, she did use the word woman. She said, Roberto said, no woman rejects me. However, in those other instances where she explained why he was doing this, she did not use the word woman. She used language such as nobody rejects me, or no, because I rejected him. Nobody rejects him because I didn't want to sleep with him.
What did he do? As I understand, he did sexually harass her, at least in terms of the language we use. I thought he also threatened her.
I believe after she had rejected him, yes.
And he
So-
threatened to kill her?
Yes, after she had rejected him.
And at least in my view, isn't it common sense that if that he was motivated, at least in part, by her gender?
He may have been motivated by her gender, and it's not just gender, it's her membership in a group of Honduran women is what she has articulated as her
And she's a
group.
Honduran woman, and he's a Honduran man. I'm just trying to think, can you really contend that he would have done the same thing to a Honduran man?
Depending on the circumstances, yes. If, for example, if he had wanted to be
But
friends.
we don't have those circumstances here. And
Right.
when you turn to, you look at Title VII, we really don't have anything in the Fourth Circuit that deal directly with this kind of issue, gender. Title VII does, and it creates that presumption that you are talking about sex in the context of sexual harassment. Why is that not instructive, or at least guidance for us here?
Well, Title VII has sex explicitly as a ground for the harm or for the improper conduct. We
But
don't
the
have
point I'm
that.
making is it makes a presumption that sexual harassment is connected to the sex or the gender of the person. And here you have a sexual harassment situation. We don't have anything here. We're sort of on a blank slate here. We haven't made that determination here. Why is that not something we can turn to? We have nothing else to turn to go there, but it seems like common sense can lead you there, but there it is in the statute.
Right. Well, I think I have two responses to that question, Your Honor. First is, again, Title VII is a different statute. It does have sex explicitly as a grounds.
But that point I'm making, but we do that all the time. We look to
Right.
other statutes for definitional purposes and determine, is there an analogy, is there some guidance
Sure.
we can get from it?
Sure.
Otherwise, we reach out on our own and on whole cloth, just sort of make up what it is. Oh, no, sexual harassment in the immigration context doesn't involve gender, or there's no presumption. I mean, we do that on our own. We can make that call. Of course, we can do that, but we got some guidance here in Title VII.
Well,
That's the only, I understand it's a difference, but there's some guidance. There's a definition there.
We have particular social group here. We have sex in Title VII. Title VII also requires other factual things like an employment type of relationship, a certain number of employees. There can be all sorts of different factors that come into play.
But I'm only dealing with the gender aspect of it in the definition of sexual harassment. I understand it has all the other elements in terms of establishing a Title VII claim. I'm not trying to do that. I'm simply pointing to the definition of sexual harassment and how it presumptively incorporates or deals with this term of gender.
I haven't looked deeply into how that presumption came about in the Title VII context, so I can't really speak well about that, other than there is an explicit statutory basis for it, and courts have looked at, I mean, that's a much more typical scenario in an employment context, to have a coworker, say, harassing another
Counsel,
coworker.
One of the things that concerns me is that we're not paying, as a general matter, we're not paying enough attention to what the standard of review is in these cases. And the standard of review is set forth by the Supreme Court, is that we're supposed to affirm in these cases and affirm the agency unless the record and the evidence compels a different reading or a different result than that was reached below. That is a stronger standard than abuse of discretion or clearly erroneous. It is, you have to have the record compel a different conclusion. And, you know, but we've adopted a very picky posture toward these immigration cases. Oh, you might not have considered this little point, or you might not have considered this little point. And we're reviewing IJ and BIA decisions more, we're scrutinizing them more carefully, more particularly, more minutely than we do district courts. And the scrutiny is detailed to an extraordinary degree when the standard of review tells us, keep your hands off unless the record compels a different conclusion. We have this very deferential standard of review and an actual practice of a searching review that is more detailed than we apply in any other context. And that's become a real problem. Everything requires a remand because there might not have been this little point that was considered. And that's not the way the Supreme Court wants us to protect this. Elias Zacharias or whatever said, you gotta deny these petitions unless the record compels a different conclusion. And the record here doesn't compel a conclusion. It's perfectly clear from the record what happened here, and that was that a private party rejected another, that one person rejected sexual advances from another person. It was private behavior. The state wasn't involved, and the purpose of the asylum statutes is to address state persecution. This is not a state persecution case. It is a disagreement and a very unfortunate unraveling of a romantic relationship, or maybe not a romantic relationship, but a sexual relationship between two private parties. And to say that there's something wrong with the record below is to open up this area to an extraordinary degree that it seems to me is at odds with the text and the purpose of the asylum statute.
I wholeheartedly agree, Your Honor, with everything you've said, and the Supreme Court has reiterated your sentiments in a recent case called Ming Dai.
Do you also agree that legal conclusions are reviewed de novo?
I do agree that legal conclusions are reviewed de novo.
And would it be a legal conclusion to say that sexual harassment is presumptively because of sex?
I can't say that in the Title VII context. That would not be.
Not Title VII, I'm saying, would it be a legal conclusion that we would make with de novo review that sexual harassment is presumptively because of sex?
As a matter of law,
As a
no.
matter of law?
No.
Well, that's a legal conclusion. Where's the fact? Where's the factual determination?
Whether this activity is on the basis of her membership in
It's
a.
not the conclusion. The conclusion is that sexual harassment is presumptively because of sex. That's a legal conclusion.
That is not an issue in this case, Your Honor. That is not what is before the court.
We
Whether
have
sexual harassment is on the basis
We
of
have a
sex.
persecutor. We have a nexus that
Right.
connects with the individual, and that nexus is connecting her as a Honduran woman in the context of the country conditions that occurred there. And speaking of the country conditions, how do you distinguish Alvarez-Logos? It surely must compel us to send it back on that basis, because that case requires the BIA and IJ to consider the country conditions, and I don't see anywhere in the record where they did. Do you?
Well, I have two responses to that. First, in Alvarez,
Give me the first response. Do you see in the record where the BIA or IJ considered the country conditions?
as a straight yes or no, no. And
No, they did not. Is that not required under Alvarez-Logos?
It is not, because petitioners never raised the country conditions to the board. And that's the argument we made in the 28J letter I filed a few days ago. In there, you look at their board brief, they never raised those country conditions to the board, either in the nexus context or in the CAT context. They made conclusory allegations about country conditions. They never pointed to a specific country conditions that says this is what supports my claim.
So
you're saying-
even just mentioning country conditions, knowing what the IJ has done, the BIA can simply just ignore it. You think that's the import of Alvarez-Logos?
They failed to exhaust it by not raising it before the board. Now you're going to say the board erred for not considering something they never presented to it. That is not what this court has said about, or any court has said about how the board operates.
Let me be sure, Mr. George, you raise an interesting point. I want to make sure I understand it. So the record evidence was the evidence presented to the IJ, right, which included the evidence of country conditions. You would concede that?
Yes, sir.
But your point is that once the case went up to the BIA, notwithstanding that that evidence was in the record, that the petitioner in this case had to point to that record and make the argument again that it made before the IJ? Is that the point?
Yes,
And
Your Honor.
what's your case, the case that supports that
I believe it's
proposition?
TEPIS, and the statute is 1252, or 8 U.S.C. 1252 D1, that any issue, particularly a factual issue like that, where a petitioner wants the board to consider evidence that the immigration judge allegedly did not consider, the petitioner needs to make that argument to the board to exhaust it in terms of judicial review.
All right. Well, let me ask this. So let's assume that that had happened in this case, and related to Judge Wynn's question and also to Judge Wilkinson's good point. I agree that, in fact, I asked your colleague on the other side that the fact that an adjudicator could have come to the result that the petitioner favored doesn't mean that that result was compelled by the record evidence. And so that's absolutely right. I mean, that's the standard But you would agree, though, that if the record evidence included evidence of country conditions, substantial evidence of country conditions, and the adjudicator had said nothing about that, even after it had been brought to his attention, that's a problem for you, right?
I agree with that generic proposition. The issue is, as Your Honor just stated it, of bringing it to the adjudicator's attention. That's our point here, of they needed to bring that country conditions evidence, the specific evidence, not just say country conditions. They need to say what country conditions support their argument and make that argument to the board. They didn't do that here, and therefore they failed to exhaust it. And the court should not consider it. That used to be a jurisdictional matter. It's no longer jurisdictional. But it means the court, because we're raising it, the court shouldn't address that issue and shouldn't decide this case on that issue.
Early on, you were trying to make a distinction between what the petitioner said and you were indicating that the reason why this, what was his name, Roberto, was pursued her was because she rejected him, just generically, and no mention of the fact that she was Honduran or a woman. So, you know, we have this particularized social group, which is accepted. We assume it's sufficient, even though you may have an argument about that, but that's not for us to decide. Working with that and the country conditions and Roberto's statements, why isn't that enough, assuming that that evidence was properly presented to the BIA?
Well, I'm going to, assuming country conditions were exhausted, I'm
Yes.
going to talk about those as if
Right.
I were the board. We need a connection between those country conditions and what is in Roberto's mind in this case. Just saying that something happens in a country doesn't mean this individual actor is acting in accordance with that. We have no idea. In fact, to the contrary, in this case, we have direct evidence of why he's doing what he's doing. And she said it over and over, because I rejected him. That's why he's acting. It's not because of country conditions or some generic mindset he might have about women or something like that. It's because this individual rejected him.
I think your point is I think the question is a good one, and I think your point is a good one, that country conditions is a very broad, sort of nebulous kind of concept. And it would just take the particulars of the asylum statute and sort of blow it up into a very open-ended proposition. And I think you're absolutely right that simply mentioning, I don't think the issue was properly raised here, but assuming it was, it still seems to me valid to say what you said, which is that country conditions doesn't relieve us of the need to rigorously analyze the particular claim and the particular petition, and whether this particular claim fits within a statute which has a particularized purpose. That, in other words, the general here does not relieve us of the analytical exercise demanded by the particular. And I think that is a very, the general conditions is a very slippery slope, and we have an obligation to draw this back into the particulars of the asylum statute.
It's for the same reasons that, in terms of looking at future harm, a petitioner can't rely simply on bad country conditions that are generically applicable to everyone in the country, because the requirement is individualized or particularized. And for those same reasons, we can't look at generalized country conditions and attribute that to this individual actor in this case, Roberto. It's all about what was he thinking, what was motivating him to take these despicable actions in this case.
It may come in, but it comes in, it seems to me, as more of a secondary factor as something that feeds in, but there has to be that foundation that is established first in terms of both the purposes and the text of the asylum statute. Now, as you go along with the analysis, after you've satisfied yourself as to that basic point, then the country conditions can come in. But it's not a leading indicator. It's a bit of it's more of a trailing factor when the foundations, when the statutory foundations have been established. And I think that's the way a lot of courts have treated it under the proof schemes that the asylum statute requires.
I agree, Your Honor.
So I think that's a valid and relevant discussion with respect to the claim for asylum, but of course, we have the separate CAT claim, which has nothing to do, at least not directly with Roberto, but with the actions or inactions of the government. So if the BIA failed to engage with the country conditions evidence and it wasn't exhausted, why isn't the result here to remand, notwithstanding that a proper adjudication we might have been compelled to affirm because the agency engaged with the evidence, but if it failed to engage with the evidence, why isn't the remedy to remand with respect to that claim?
Well, here the agency did engage with the individualized evidence that petitioner presented. He looked at, or the immigration judge and the board looked at what petitioner actually did in this case. She made a police report, and the police took that report. There are some positive factors in terms of they took the report. There's some negative factors maybe in that she tried to call a couple times and no one answered. But sort of as Judge Wilkinson pointed out, this time frame for all the events in this case is about a week, maybe 8 days, and then she left the country. We simply don't know what happened after that. So we're left with this just absence of evidence. And country conditions is not going to be something that's can fill that in this individualized, particularized situation.
But, it seems to me, you have a petition that goes extensively before the IJ, lays out the country conditions, and then she goes before the BIA and states that the country conditions evidence shows that the Honduran government is not merely unable to stop abuse, but it's also willfully blind to it. That you would hear that even as a judge or on this court. I mean, when you say it's there, someone has to say, well, what is that evidence? Rather than to just, well, I'm going to ultimately just rule against you because that tells me you haven't told me what the evidence is. I mean, this is a process in which we are seeking as an element of justice to the whole process, not one in which we are trying to play cat and mouse and got you on it. And they didn't even address that. I mean, even if she didn't specifically say it, but to say that the country evidence shows that they not only didn't stop it, but they were willfully blind to it, there's nothing there that addresses that. And when you look at the attenuating cases that you point to, which I'm going to do, I want to determine from those cases, did that individual say anything of that nature here in the general, even in a generalized label, or did they just not bring it up? Which is a wholly different situation. And because I want to, when the other side gets up, often what happens is you say something, then I'm going to hear something on the other side. You're not going to have a chance to respond to that. And so I'm giving you a chance to respond to that. Is it really waiver, as you say, and to get that, of course, you have to present it to the Lord, present it to us properly to say that is the case. Or is it a situation that's a matter of degree that, okay, she didn't say all of that, but she said country conditions and she pointed to them, but the BIA did nothing. And when you look at Alvarez-Lopez, that's not the way this should go. That's a remand for them to consider it. And even if you do that, what's the big harm with that? I mean, at the end of the day, what we're trying to do is do the right thing, not just, again, a got you situation or this is a condition in which you could try to make it out that it's a romantic situation or not. It's surely not. This woman, there's all kinds of evidence of her in terms of previous situations. She is constantly being abused in many settings. This particular one, he's not just someone who's luring her with flowers and as it seems to be painted here, that this is a nice little thing. He's making advances. He's stalking her. He's coming up on her job. She not only rejects her, she's rebuffing her. She turns and goes to the police. And okay, it's a week later. Well, it's an imminent threat. And they do nothing. They just take the report, they look at it, they do nothing, absolutely nothing, for a whole week. A week is a long time. It can be 10 years. You can be dead in a week like you can if you wait for 10 years on it. And so it's not just the delay in terms of the response of police. There's no response in that. And so when we look at the circumstances of this is what we get to the meat of it, you know, when we're dealing with the circumstances of this case. So I think that's a distinction, but respond at least to the contention that something was said here, and it was more than just a generalized statement. It was a statement that the conditions show that this government was not merely unable to stop abuse, it was willfully blind to it, and they ignored it. There's nothing there.
Judge Diaz, may I have
Sure.
time to respond?
Yeah.
Judge Nguyen, I point you to JA 32, which is the sole page where petitioners make their argument regarding country conditions for CAT to the board. And if you read what they said there, the skeletal sort of bare bones argument, they just conclusively say country conditions. I doubt this court would accept that from a litigant appealing a district court decision, essentially telling this court, you look through the district court record, you find the country conditions or evidence I'm talking about, and make an argument for me that supports what I'm trying to
Come
say.
back here to the basic point of whose burden was it to make out the claim? And it's the petitioner's burden to make out an asylum claim, and it's a petitioner's burden to make out a CAT claim. And you have to produce some evidence that there's going to be a likelihood of torture if the individual if the petition is denied. That's a high standard, that there's going to be a likelihood of torture. And the petitioner bears the burden. It's not the government's burden to produce that evidence. It's petitioner's burden. And the point is, this kind of passing reference and skeletal reference just doesn't make the case.
Judge Diaz, may I respond?
Sure.
I agree, Your Honor. That's essentially the point we're making.
But you have to come back to whose burden is it?
Oh, it's absolutely petitioner's burden.
Well, one point on that. So you got an IJ where you got all this evidence. She then cites to that evidence and says the evidence, the conditioned evidence shows that this is so. And you're saying that all of the evidence that is before the board from the IJ, they can ignore it, even if you reference it or say it. If you don't go back and repeat exactly what you said to the IJ and it's right in front of you, then they can ignore it. Is that essentially where we are? That evidence presented to the IJ that is referenced or pointed to before the BIA can ignore it, even though it is looking right at that evidence.
If it were referenced like Your Honor just said, no, I wouldn't be making this
The
argument.
quote is, country conditions evidence shows that the Honduran government is not merely unable to stop abuse of women, but is willfully blind to it. That evidence is right there in front of it. It's not something out in space. And I'm saying when we go look at the cases you cite, I want to know, is there anything like this in that case? Now, it's one thing to not bring it up at all, but to have it right in front of you, that's an insult to justice. To have it right in front of you, and all this evidence is there, and I'm not even going to look at it, even though it's right there. And I can't do that and say, okay, you waived it because you didn't stand in front of me and pick up that contract and read everything that went before below.
That is the standard. They need to point it out. And that's the standard I believe this court would apply to, say, a district court record If a litigant came before this court and just said, I presented the evidence to the district court, Court of Appeals, you go find it.
You still have, at the end of the day,
We do it all the time.
an obligation to deal with the particular claim that is before the court. The particular claim that is before the court is the petitioner likely to be tortured upon return, a likelihood of torture. And you could talk about country conditions and the like, but that doesn't relieve two things. It doesn't relieve the fact that it's the petitioner's burden, and it doesn't relieve the court of the need to analyze the particular case and whether there is a reasonable opportunity that the government would acquiesce in the torture here. You cannot get away from the particulars of the case by citing some general condition. You cannot relieve someone of the burden of proof and the burden to bring forward evidence. And this wasn't, it wasn't done. I don't think she was restricted in any way from bringing forth evidence that there would be a likelihood of torture in her particular case. And we have to analyze these cases. We can't just, talk about this generality and this generality. We have to analyze these cases in terms of the person that brought it and a particular situation and who has the burden. And it's the way we analyze every other case, every other category of cases.
All right, thank you, Mr. George.
Thank you.
Your Honors, the first thing I'd like to address is the exhaustion argument that was raised for the first time 2 days ago in a 28J letter, ironically. It raises...
You mean it wasn't in the brief?
It was not in the brief.
You mean
It
you
was...
didn't bring it up to us before the letter comes out?
No, I would argue that it is an argument that is waived, but it's also factually
He said you
incorrect.
waived it. He says you waived because when you went to BIA, you didn't recount all of the evidence you put to IJ.
We did, we weren't counsel at the board, but the counsel at the board did raise these issues specifically. And I would point the court to to the joint appendix at 29, where country conditions evidence is clearly identified, citing joint appendix 232 at paragraph 26, Claudia Hermansdorfer. Also, she incorporated those arguments by reference into her CAT argument at 32, stating, moreover, as is shown herein, country conditions evidence that the Honduran government is not merely unable to stop abuse of women, but is willfully blind to it. Additionally...
Can you bring up the issue of waiver in a 28J letter? I mean, is that the way you bring up an issue that you missed on your brief?
No, Your Honor, and I believe this court recently weighed in on that, well, first of all, it was procedurally improper to raise an argument in a 28J letter, and it was non-responsive to the point of our 28J letter, which was to call this court's attention to its decision in Guandique Romero, and additionally, it was inconsistent with other 28J response from the government, which was filed on February 25th, 2025, which had the opposite argument. The suggestion there was that the board obviously considered the country conditions evidence because it had cited to the brief in its decision. So not only is it internally inconsistent, these arguments, but they waived it by not raising it in their previous brief. And it suggests to me that it's an acknowledgement that the agency did not consider country conditions evidence, and that there really is
Counsel,
not a
let me
defense
ask
for
you
that.
this. Were you restricted in any way from developing the evidence around with respect to your cat claim?
I'm sorry, say again?
Were you restricted in any way from putting on evidence or developing your cat claim?
I mean, I would say that there's a separate argument there that is not before this court about how the immigration court hearing was
I'm
conducted,
asking-
but
please,
with
please give.
with respect to,
I'm asking you whether you, in proceedings earlier in this case, before the IJ and the BIA and all the agency proceedings, were you restricted in any way from developing your claim under CAT?
again, I think there are issues before this court, and I would say that yes, but it's not before this court.
So the answer is no.
With the, no, the answer is yes, but.
The answer is no, you weren't restricted. And I'm wondering why you didn't make more. If you think you've got a good claim, why did you not make more of it at the agency level? Why, the CAT claim, why didn't you develop it to a greater extent than is evident from what is before us here?
Your Honor, I would posit that there is more than sufficient evidence here of government acquiescence on Kat, and also that she suffered harm that rises to the level of Kat, and that she faces torture, and that she faces future torture. The harm piece and the future torture piece are not before this court because the agency didn't consider them. However, the acquiescence piece is. And on this record, she has met her burden, and the agency clearly erred by not considering any of the overwhelming country conditions evidence of impunity for violence against women. I see I'm running low on, or I'm over time, but I just quickly like to address, if possible, the legal error in the nexus piece, and a factual claim that the government made about statements on her statements about being a woman.
Very quickly.
She stated repeatedly that she was targeted, in her testimony, that she was targeted on account of her sex. I would point the court to Joint Appendix 211 and Joint Appendix 180. And I would also note that at a minimum, even if the court determines that substantial evidence does not demonstrate nexus to the declared particular social groups, that at a minimum it should remand because the agency failed to consider, once it decided that there was a private or criminal motivation, it failed to consider whether or not one central reason that she was targeted was also her sex. And its failure to do so is inconsistent with this court's precedents, and therefore, at a minimum, should be remanded for consideration under the correct legal standards. And if there's nothing further, thank you, Your Honors.
Thank you, Ms. Peterson. I know, I think you mentioned this at the very beginning, or Ms. Sangueza did, that you were both pro bono counsel for Ms. Alfaro Celaya, and we appreciate your taking on her case and ably presenting it to the court this morning. And Mr. George, thank you very much for your arguments this morning. We'll come down and greet you and move on to our second case. All right, our second case is 23-4313, United States versus Henderson. Mr. Byrne?
Morning, Your Honors. May it please the Court. My name is Jonathan Byrne. I'm appearing this morning on behalf of Michael Henderson, the defendant below. Rule 32 of the Rules of Criminal Procedure lay out requirements for objecting to the calculations made by a probation officer in a pre-sentence investigation report, a PSR. The government failed to abide by those requirements. Rule 32 also provides for later objections to be made on the basis of good cause shown. The government never even tried to make a showing of good cause, nor could it. And the district court did not make a finding that there was good cause to excuse the government's failure to object to the PSR. Instead, the government made new objections months after the PSR was initially prepared and weeks after it was finalized in response to an order of the district court addressing the issue of safety valve relief, not the calculation of the advisory guideline range. The district court abused its discretion in considering the district court abused its discretion in considering the government's untimely objections and imposing enhancements to the guidelines at sentencing as a result. I think in this case, more than others, the timeline is really, really important. Mr. Henderson entered his guilty plea on October 6th of 2022. And at the same time, the district court entered a sentencing order laying out a deadline for the draft PSR to be prepared, objections to be made, and the final PSR to be prepared. The district court did grant...
Why doesn't the district court have an overall obligation to figure out and find what precisely is the just sentence? To do that, the district court got to analyze statutory questions. It's got to analyze questions under the guidelines. Why would we get in the way of what the district court's ultimate obligation and burden is, which is to arrive at the end of the day when the sun goes down at a sentence that reflects justice in its fullest extent? Why would we prohibit the district court from considering enhancements that may or may not figure into the correctness of an ultimate sentence?
I think there are a couple of separate issues there to unpack, if I could. One certainly is we don't disagree that under Gall and this court's decisions interpreting Gall, the district court has an obligation to correctly calculate the guideline range. That's obviously true. What I was unable to find were any cases that really discussed the issue of how that interacts with the general principle of party presentation. And what we have in this case is a situation where there was a draft PSR that was prepared. It included a 2-level enhancement for the firearm and no other enhancements. Mr. Henderson made an objection. In the Southern District of West Virginia, those objections go to the probation officer and they go to the government. They are not filed on the record. That objection was persuasive. The probation officer removed the 2-level enhancement. So when the final PSR was prepared, there was no 2-level enhancement recommended.
But weren't there some cases that came down in the interim that raised the question of eligibility for the safety valve?
The statutory safety valve, Your Honor, yes, and that was Jones. That's the district court entered the order about Jones, but the district court's order specifically directed the parties to.
Wasn't it necessary to decide the enhancements in order to find out whether there was safety valve eligibility?
At the time the district court entered that order, there was no dispute over any of the enhancements.
Right, I know, but I'm saying when the district court revisited the question after the case law came down, and the question was raised in the district court's mind the question of eligibility for the safety valve. And why wouldn't the district court be allowed to consider the applicability of enhancements that would reflect on that eligibility? I mean, the bottom line, it seems, is that we should not get in the way of the district court organizing its proof and its determinations to fulfill its ultimate obligation of arriving at a just sentence, both from the standpoint of the defendant and the standpoint of the government. And seems to me you want to establish a roadblock there.
I don't want to establish a roadblock, Your Honor. I want the government to abide by the requirements of Rule 32 the same way the defendant would have to. We cited multiple cases in our briefs where defendants fail to make timely objections, ask for dispensation for good cause, it's not given, and that's it. They're stuck with that. It's an original sin that will follow them through the rest of their case. All we want is for the government to abide by the same rules. And if the district court does want to revisit guideline calculation issues.
Why isn't there cause here when you have intervening case law that suggests to the district court that may or may not be eligible for a safety valve, and the district court says, I'm going to consider all the evidence that's pertinent to that. And it's troubling to me, in addition, is that all of this is about a procedure, and I don't think anybody has disputed particularly. I know you've made some arguments, but as far as the leadership enhancement and as far as the firearms enhancement, it doesn't seem to me that there's much dispute. Well, yes, the district court, there's a perfect basis for the application of these enhancements. There's evidence upon evidence that this person was running a drug ring from inside the prison. Of course he's a leadership, he's occupying a leadership enhancement. And he's referring to pistols and his firearms as his puppies and giving orders to this person and that person about what they should do with his puppies and what firearms they should bring to a transaction. That fits plainly within constructive possession. And here are these enhancements that plainly, clearly, indisputably, it seems to me, ultimately apply, and we're going to prohibit the district court from considering what it needs to consider in light of intervening authority as to whether the eligibility for safety valve consideration or not. I don't know. We seem to be getting in the way of justice here.
Well, Your Honor, the intervening authority in this case was Jones, which didn't have anything to do with firearms or leadership, number one. Number two, we did challenge the facts in the PSR as to the firearm enhancement. We did it in the process set forth in Rule 32, and the probation officer found that credible. And because the probation officer found that credible and the government failed to object to it earlier, the district court did not have that argument before it when it ruled on the enhancements. As for the leadership role, the probation officer didn't recommend that in the PSR. The government didn't object to that. We relied on that in making the argument about the safety valve. It just simply wasn't an issue. And the Jones order that Judge Berger entered did not say any guideline issue that might be relevant to this is to be reopened. It pointed out that there was no firearm enhancement recommended or leadership role recommended, but it didn't say, and if there are issues with that, I want to hear from the parties on that. There have been, just speaking from experience, there have been cases below in our court where at some point in the sentencing process, the district court judge says, hey, parties, I think you may have missed something here. And it's gone both ways. It's been I think there's an enhancement that might apply here. I think there's an enhancement that's in the PSR that nobody objected to that might not apply. I want you to brief
Well,
us.
you know,
And that's what didn't happen in this case.
we've gone over and over, and we have said the district courts have the ultimate and independent obligation to find the correct guidelines range. That's what a district court's supposed to do, and if it fails to do that, we send it back. And here is somebody who is trying, here's a district judge that is trying to do what we said, which is to find the correct guidelines range. And we're not gonna allow him to do that job?
No, Your Honor, I'm perfectly willing to concede that the district court should be allowed to do that job, but it has to come within the confines of the rules, and it has to be within the confines of allowing the parties to present the arguments on the relevant enhancements. I mean, that I think is the bottom line in this case, is that, especially on the firearm enhancement, Judge Berger's order imposing the enhancement said that Mr. Henderson doesn't challenge the facts in the PSR. Mr. Henderson had challenged the facts in the PSR successfully, and that's why it was not before the court when...
I thought the district court statement was in the context of not challenging the facts at the sentencing hearing.
I'm sorry, Your Honor?
I thought the district court's statement that the defendant did not challenge the facts was in the context of not challenging them or at the sentencing hearing, not at the PSR level.
It was in the order resolving the safety valve issue, which is where the objections were ruled on. By the time we got to the actual sentencing hearing, that decision had been made.
Right, but there was no objection to the facts there, is the point, right?
No, because at that point, the decision on the firearm enhancement had been made. And this court has said that once a decision's been made by the district court, the parties don't have an obligation to essentially raise it again.
Okay. Well, let me ask this. So I think I recognize Mr. Henderson's and your perhaps frustration with the way this all went down, because it started out with perhaps an opportunity for Mr. Henderson to benefit from the safety valve provision. And the way it worked out is not only did he not benefit from that provision, but his sentence was enhanced because of arguments that you say should have been brought earlier, in fact, were brought earlier in the process and rejected by the probation officer without an objection from the government. And that all may be true. But, and then you point out the fact that defendants don't get the same pass. But in those cases that you're talking about where defendants don't get the same pass, they're not quite on all fours with this case, are they?
They wouldn't be exactly on all fours. This is a unique situation in my experience.
And I think that's to Judge Wilkinson's point, is that the district court was trying to do the right thing by getting to the appropriate sentence and then asked the parties to brief why the safety valve didn't apply. And it was in that context that these enhancements are adjudicated. I mean, why isn't that, back to Judge Wilkinson's point, why isn't that good cause?
Because I think if the district court had said, and as a part of that, if there are guideline calculation issues we also need to resolve, I want to hear about those, then we wouldn't be here. But that's not what the order says. The order says, this is coming out in the wake of Jones. What is his eligibility for the safety valve? And at the time, the only element for safety valve eligibility that directly tracks to a guideline enhancement is the leadership role, and the PSR said he does not get a leadership role enhancement. We relied on that. And I think it's important, and this goes back to the timeline, the supplemental briefing on the Jones order were both due on the same day. So it was not a situation where the government filed, we filed a response, the government filed a reply. We were frankly blindsided by what the government did.
Time after time, we have chided district courts for not taking sentencings seriously enough and for not considering this or that or the other. And we say, oh, to district courts, you were too casual, you didn't take this into account, you didn't do a thorough job here. And here we have a situation where the district court is trying to do a thorough job, which is what we've encouraged them to do. And we're saying, oh, here you did too thorough a job. You proceeded too carefully. And we've many a time have lamented that the district court didn't give more consideration to all the different factors that might bear upon a sentence. And now here, district court is trying to do that very thing, which is to proceed as conscientiously as she knew how to do what we've encouraged them to do. Then why should we jump in and say, oh, you did too much?
May I respond to that?
Go ahead.
I would say in this is not a situation where the judge did too much, because more needed to be done if these guideline calculation issues were going to be reopened at that later date. And while I'm certainly sympathetic to the need to not micromanage the district court and to recognize the effort that district judges put into getting these things right, sometimes they still fall a little short, and this is one of those cases. Thank you.
Thank you, Mr. Byrne. Mr. Goes?
Thank you, Your Honors, and may it please the court. The district court did not abuse her discretion in correctly calculating the sentencing guidelines, and in this case, the sentence should be affirmed. When the district court noticed a discrepancy between the facts in the pre-sentence report and the parties' objections in the pre-sentence report, she did what I would hope any judge would do under those circumstances: ask the parties to address the factual discrepancy in writing.
Could the defendant have said, I don't want you to consider this safety valve approach? I mean, could he just said, don't do it, or was the judge required to do it?
In light of Jones, the court asked for written briefing. So to the extent that the court was required to do it, I would say that's best practice as opposed to required, to see what is the impact of Jones. But also on Jones, there's other criteria for the.
You know, you think about it and what happened here. You're in a criminal case, as a criminal defense lawyer, you're advising your client. You have one guideline, it's pretty favorable. And you get something that, as Judge Diaz alluded to, that's being brought that's potentially is gonna make it even more favorable, but it turns out completely the opposite way, because it allows you to go back and revisit. And I don't think that's incorrect that the judge can do that now. Because I think in the context, and maybe correct me, that if neither party nor the PSR applied an enhancement, the judge could still look at the record and determine on its own that there's an enhancement period. It's that independence that Judge Wilkerson is alluding to, and it's pretty clear, you know, in terms of a focus that's there. But in this particular case, it's rather unique that in proceeding, even in advising, I'm thinking as a defense counsel, how do you advise a client when there's this benefit that you perceive is going to happen? Probably said, oh, this is good. And at the end of the day, oh no, it was not good, because now it opened the door to go back and revisit these things for the judge. Without this safety enhancement issue being brought up, I take it would still be your position the judge could change her mind at any point, even after having ruled on it that you were not going to consider those other factors that found. Is that true?
That is our position, Your Honor. In fact,
Okay.
that's the court's position in her written order. When she addressed the waiver argument, she says, this wasn't waived. I invited additional briefing specifically from the parties to address this, so I don't consider these arguments waived. But alternatively, the court has an independent obligation to get the guidelines right.
Well, at what point in the trial, I'm just thinking, this is back to the lawyer side, represent the client. At what point can you tell your client, okay, this is good? Because it sounds to me that a court can actually, ruling in the defendant's favor, proceed on, say, okay, this is what we're gonna do, get ready to do sentences. You know, I changed my mind, I wanna go ahead and put this back in. And, you know, with the independent obligation, that's there, but it just seems to me that none of this exists. Maybe even can reopen it after sentencing and say, you know, I gave that sentence, but I want to go back and revisit this. Is there some kind of limitation here And of course, that's not the facts here, but I'm just thinking it leads to that result somewhat, to at least in terms of where does this go from here?
We would submit, even if, at the end of the day, if the court believes the accurate guideline calculation should be made, the court should make the accurate guideline calculation. If the parties think that's too unfair or that's shaking things up too
And it
much,
can cut both ways, I take it.
100%, Your
The
Honor.
judge could get to the end of it, says, I didn't put it in, I want to put it, I want to give you this value of not having an enhancement too. So you're saying the judge has that discretion to go back and forth on this because it's an independent duty at all times. And there's no point during that sentencing proceeding does it become something the defendant can rely on as being, that's the way it's going to be, because at any moment the judge could change her mind.
Let me address that in a couple ways because it's important. You can't rely on it too much because, of course, they're advisory guidelines, and Judge Berger correctly noted that these are, in fact, advisory guidelines. I would also wanted to address your question on point. I started out my career as a defense lawyer, and I know one of the scariest questions you can ask or receive from a client is, what am I looking at here? And I think every one of us in this courtroom knows the answer is, it depends on the judge. Here's what we think you're looking at, but the ultimate discretion is in whose hands? The court's hands. And to Judge Wilkinson's...
And that's even after the prosecutor in the case is agreeing with you, the PSR is some way, and everybody's going in that direction, but at the last minute, the judge can do this. But I'm not saying that's... I'm only just saying, I just want to make sure I understand how this works in terms of this independence of the judge. This case, it seems to be there, that the judge can do this, but I don't know what the implications are beyond that, so it would be scary.
I'll concede the better practice, of course, would have been for the parties below to have raised these issues, both on the safety valve and on the government side. It is the better practice to raise those issues. That's why what Judge Berger did is so precisely correct, which is to say, if the judge notices a discrepancy in the facts of the pre-sentence report and what the parties are, she's asking the courts to address this. She could do it directly at sentencing, but here she entered a written order saying, please address the discrepancies in light of the new Jones decision, but in light of the other criteria under the safety valve, which are the leadership role, the possession of the gun, the acceptance of responsibility, because there were facts in the pre-sentence report at odds with what the parties took.
One thing in thinking about what the district judge's obligations are, one of the district judge's obligations are to this court, and what we have said about the obligation the district court has to reach a correct sentence at the end of the day. But I think there's another obligation in addition to the obligation that this court has imposed on district judges. There's an obligation to Congress and the Sentencing Commission to get these guidelines calculations correct. And there's a further obligation to the Congress of the United States, which set forth the elements of the safety valve provision. It didn't just want the safety valve provision to be handed out willy-nilly. And so I think there's an obligation to Congress that has passed the safety valve provision, that we apply the safety valve provision in accord with Congress's wishes, that those who are eligible should receive it, and those who are not eligible should not receive it, and the district judge is trying to figure it out. So I think there's an obligation to this court, what we've demanded of district judges. I think there's an obligation to the Sentencing Commission to do these calculations correctly, and I think there's an obligation to Congress to apply the the safety valve provision in the manner that the legislative branch of this country intended. And there are all kinds of obligations here that the district court was attempting to satisfy. And it seems to us to say, oh no, you abused your discretion, would just frustrate so much of what we're trying to do.
Well, we agree completely, and that's why the standard is abuse of discretion, and that's why the court is setting the parties up in the best possible way, which is asking for written pleadings, having everyone have the opportunity to evaluate. I would submit that's why this court wants written pleadings before we show up to argue, so that everyone has time to consider what the arguments are in advance. And
Mr.
Judge Berger addressed the issue of the waiver head-on, as well as the inconsistencies in the facts in doing her independent analysis, as is required by Gall and the Sentencing Commission, and did sentence him within an advisory guideline range because she recognized this is a serious offense. Methamphetamine trafficking is serious, and he's looking at a lot of time. She's still varied downward. He got a considerable break anyway, but she recognized the import of the sentence here. But this is what you would hope a judge would do. I've stood in these shoes before. Sometimes you miss things, and you hope a judge will point it out, preferably without yelling at you, but you always want a judge to say, the parties may have missed something here, can you address it? And
Do you think it would have been an abuse of discretion for the district court in this case to say, government, I hear you with respect to why you don't think the defendant is entitled to the safety valve because you've made arguments that in fact there are a couple of enhancements that apply in this case that nullify his entitlement to the safety valve. So your objection to application of the safety valve is sustained, but government, you didn't bring up these enhancements at the point in time at the PSR time when the probation officer was supposed to be considering these, and so you waived those, and I'm not going to apply them. Is that an abuse of discretion?
That would not necessarily be an abuse of discretion, Your Honor, with the important caveat that the calculation should be right. So, and that was why the judge raised the issue in the first place.
Well, it
So
sounds like you're suggesting that that would be an abuse of discretion.
if the leadership enhancement should have been applied, then it would be an abuse of discretion of the court to say, I'm just simply not going to apply it based on the facts. And that's why we would submit the facts and getting the guideline is more important than the rule, than the waiver language under Rule 32. Or that at the
But
very
Mr.
least would
Byrne,
be good
he
cause.
raises the point that district courts all the time make rulings that essentially say, Mr. Defendant, you have forfeited any argument that a particular reduction would apply because you didn't bring it up at the appropriate time.
That's true, Your Honor.
So why shouldn't that apply to the government?
It does apply to the government.
So it wouldn't be an abuse of discretion, would it, for the judge in this case to have said, you've made great points about the reason why the safety valve shouldn't apply, but I'm not going to apply the enhancements because the government didn't raise those issues when it should have.
I'll defer to Judge Berger, who sort of answered that question, which is why she said the waiver doesn't apply. She said, I invited the briefing, but on top of that, the court has an independent obligation to get the facts right. So if getting the facts right is the good cause necessary for the court to arrive at the correct calculation, then yes, the court should always arrive at the correct calculation. Failure to arrive at a correct calculation could risk an abuse of discretion. But again, courts have enormous latitude to try to determine the factual basis of these guidelines. So that's how the court addressed it.
When we're talking about cause, the term cause in the law is vague, and it is not defined what cause is. That's left open. And when a term like cause is left open, that means that there's some latitude on the part of the sentencing judge to determine what's cause and what's not cause. That's the term cause as a term of art almost is something that reposes discretion in the person that finds cause to be present or cause to be absent. But it's a discretionary term. It's a term that leaves latitude, and it certainly seems fair when intervening authority comes that suggests the need for supplemental briefing, and then the appearance of enhancements to determine eligibility for safety valve consideration. This is not just whether the district court let the government off free. It's a question where there was a very concrete reason for the district court to request supplemental briefing. And I would say that this court requests supplemental briefing all the time. And for the very reason that Judge Berger suggested the need for supplemental briefing. There's intervening authority that we want supplemental briefing to elucidate. And I don't think that's an abuse of discretion on our part to ask the parties to have supplemental briefing because of intervening authority. That's all the district judge did. And that's routine for courts. And sometimes the supplemental briefing suggests questions that weren't apparent before. But I don't see how it could be, you know, an abuse of discretion. Reversal is a pretty rough thing. And to be reversing is an abuse of discretion. This fine district judge who was trying to come to the right result for the right reasons and was trying to apply the thorough consideration that we've required of him to say, you abused your discretion, you took too much time, you took too much care.
Your Honor, the good cause
We can't, that's bad.
We certainly agree. The good cause definition is very broad. Legally sufficient ground or reason, circumstances in the discretion of the court. That's from Black's Law Dictionary. That's the best I can come up with. So it's not only somewhat circular, it's designed to afford courts discretion because we're trying to get it right. And when we look at the abuse of discretion, at the end of the day, what we're seeking is a just result. What is a just outcome? That the judge advises the guideline calculations or devises them correctly, properly, based on the facts in evidence, and then applies that sentence in an advisory fashion while, you know, looking at the other 3553A factors. That's precisely what was done in this case. That's precisely what was done with the two-level gun enhancement in this case. And that's why we think the court did not abuse their discretion in correctly calculating the sentence, and the defendant's conviction should be affirmed. Are there any other questions?
All right, thank you, Mr. Goes.
Thank you.
I wanted to go back to the scenarios you were running through with Mr. Goes, Judge Wynn, and this issue of what district courts can do in absence of argument from the parties on guideline enhancements or other sentencing issues. I think there is a distinction. It's a fine one, but it's an important one between the judge at some point in the process later than the rules contemplate saying, there's an issue here, I think we need to deal with it, and the judge at the end of the day saying, without hearing full argument from the parties, I'm going to impose this enhancement, or I'm going to not impose this enhancement. And I think this case is more like that than the supplemental briefing example that Judge Wilkinson brought up, because in that instance, you've got the parties arguing about the same thing. If the government, in their response to a supplemental briefing on new developments of case law, said, oh, by the way, there's another basis to rule in our favor, and it's 10 years old, I think that's a different situation. Another thing is I would really direct your honors to, it's on page 30 of the joint appendix, it's the order that Judge Berger entered. And what it says is that although the PSR did not recommend enhancements related to firearms or a leadership or managerial role, and did recommend an acceptance of responsibility reduction, based on the facts of the PSR surrounding those issues, the court finds it appropriate to give the parties an opportunity to address the implication of Jones and whether Mr. Henderson meets the remaining safety valve criterion. In other words, the PSR already says these two things don't apply. Jones indicates he may be eligible based on his criminal history. Is he otherwise eligible? I think the district court's conclusion later about waiver saying this order invited additional arguments on the guideline elements just doesn't match up with that language. The other thing I wanted to point out in terms of enhancement is the burden of proof for guideline enhancements rests rests with the government. And so when a defense attorney sits down with his client and go through the PSR and say, well, you may get this enhancement, you may get that enhancement. The PSR comes back and it doesn't recommend that, and the government doesn't object. You're sort of entitled to say, well, the government must not think they can prove that, and we're going to move on with that. I think that's important. The other issue is, Judge Wilkinson, you were talking about the various authorities, essentially, that the district court's trying to comply with, the Sentencing Commission, Congress, and all that. Rule 32 is that too. Rule 32 started out in the judiciary. It was approved by Congress. It is designed to produce a system wherein the parties are aware of what the disputes are. Oftentimes, when I get a case to start briefing, and there are sentencing issues, the first place I go is the objections to the PSR, because that shows what was kind of at issue. And
I've always enjoyed your arguments, Mr. Byrne, and I understand what you're saying, and that is that the part of what the Sentencing Commission and Congress wanted was an orderly system where objections and proof proceed in an orderly fashion. But there is still the obligation of a district judge to apply the enactments of Congress correctly. And I wonder at the end of the day whether we can leave saying that we didn't allow a district judge to apply a leadership enhancement to someone who was really operating in great detail a drug ring from inside prisons. Those instructions that this individual gave from within the prison walls to lieutenants outside the prison walls, they concern what drugs, they concern quantity of drugs, they concern what weapons should be brought to the drug deals, all of those things. And I hear you when you talk about part of what we've been given by Congress and the Sentencing Commission as a system of proof and waiver and all of those kinds of things. But when you get to the bottom of it here, the safety valve provision is a matter of grace. And this is a very serious thing that went on here. And prisons are facing every day people who are still not abandoning their conspiracies and their drug operations simply because they've been incarcerated. It's like it's uninterrupted. And the enhancement here seems to be so obviously applicable. It'd be a rough thing to say that a district judge abused his discretion in applying it. I'm having a hard time with it.
Can I respond to that briefly, Your Honor? What I would say to that is, first of all, we haven't challenged specifically the leadership enhancement on appeal, the way we did the gun enhancement. But secondly, the evidence that's in the PSR, which is all we have, didn't convince the probation officer, and it didn't convince the government to file an objection for months. And so it's not as clear a question as I think it otherwise could be. But I will leave it at that. Thank you, Your Honors.
Thank you, Mr. Byrne. I want to thank both counsel for their fine arguments in this case. We'll come down and greet you and take a brief recess before moving. Our third case is 23-4538, United States versus Palmer. Mr. Martin. Whenever you're ready.
May it please the court. Jared Paul Martin on behalf of Gregory Maxwell Palmer. This case is about Mr. Palmer's developmental language disorder and the court's evidentiary errors that prevented him from presenting a full and fair defense. The crux of Mr. Palmer's defense was that he reads and understands at a 4th grade level, and that he did not understand question 15, which is at an 8th grade level. The court's ruling about grade levels left Mr. Palmer unable to explain his language disorder and the difficulty of question 15 in a framework a jury could understand. The government then exploited that ruling by itself using grade levels to prove mens rea. In its closing, the government argued that Mr. Palmer understood the question because he reported an 11th grade reading level on a form. Because Dr. Fahey's testimony about grade levels undercuts every piece of evidence the government relied on.
Your argument is that he wasn't given an opportunity to have the kind of witnesses that he wanted. Is that right? In other words, that he just didn't get to present the evidence he wanted to present. In other words, he didn't get to present his mother and others there. Is that your argument here?
Yes, so as far as the expert testimony, Your Honor.
Because the evidence that you are saying wasn't presented is coming from, it would come from somewhere. And where would it come from?
So the evidence would have come from Dr. Fahey. She was the expert in the case. That her testimony was admitted, but the court did not allow her to testify about grade levels under Rule 704. And our argument is—
The court couldn't. I mean, if she was testifying regarding mens rea of the defendant, is that permitted in a criminal case?
So she can't testify to the ultimate issue of mens rea.
That's right.
But she can testify about inferences that can lead a jury itself to determine that ultimate mens rea. And that's what she should have been able to do here, because it would have explained his mental health disorder in a way that a jury could understand. The grade level testimony is vital, strong, and unique evidence for at least 3 reasons. In Diaz, Justice Jackson highlighted that mental state evidence can be of critical assistance and play a pivotal role in helping jurors to better understand complicated mental health issues. And that's what we have here. Testimony about grade levels explains the language disorder. Everyone understands grade levels. He understands at the 4th grade. He understands at the 3rd grade. He reads at the high school level. This testimony contextualizing the grade level at which Mr. Palmer could listen and read would have helped jurors better understand this complicated language disorder and would have provided reasonable doubt as to whether he knowingly lied on the application.
Is there an argument that, assuming that this was an error, that there was other evidence in the record that essentially said the same thing, including evidence relating to the fact that your client scored in the 2nd and 1st percentiles on reading tests and similar evidence, such that this evidence might at best have been cumulative and therefore harmless?
I don't think it would have been cumulative, Your Honor, because it was just so vital. And if you look at the—
Okay, why is that?
Why the testimony is so vital?
Yeah.
Because it explains his mental health
Yeah,
disorder.
I'm sorry.
I'm
And
sorry.
vital in a context different from the other evidence already in the record.
Yes, so the other evidence in the record, Dr. Fahey testified about his language disorder, but she wasn't able to do it in a framework that a jury would understand. And she also wasn't able to explain the difficulty level of question 15. It's a confusing question. Have you ever committed a crime or offense for which you're not arrested? What does that mean? The question has actually been changed since then. It no longer asks that, and I think we all know why, because that's confusing. But her testimony would have explained to a jury that question is at least at an 8th grade level up to a high school level. And then the jury could look at the disparity between that and this fourth grade reading level, and then draw their ultimate conclusion about mens rea. We didn't ask Dr. Fahey to testify about mental state. We didn't ask her to testify about the element of the crime charge. We asked her to present evidence about grade levels that the jury would be able to understand. And the fact that she didn't do that, Mr. Palmer wasn't able to present a full and fair defense.
What is it about that question that's confusing?
It's because I think there's a lot of ways you can interpret it because it uses the term arrest. And I think, you think of arrest like, well, I've never had any law enforcement contact. I think it's confusing, and I think that's why it was changed. Have you ever committed a crime or offense for which you're not arrested? It's tough, And Dr. Fahey's testimony could have explained how tough that is, and it's at least at an 8th grade level. And a jury should have been able to hear that evidence.
All due respect to 8th graders, and it's probably a lot about 8th grade schooling that I don't remember, but that 8th grade level doesn't seem that tough.
I have to respectfully disagree, Your Honor. I think it's a confusing question. I think that's why they changed it in the application. And I think jurors should have been able to make that determination. Can my 3rd grade daughter understand this question? I don't think so. A jury that information should have been presented to the jury. It wasn't. And the problematic thing is the judge didn't allow it in under Rule 704. That was a violation. I think Diaz makes clear that was a violation. Grade levels are not mental evidence. Grade levels are not mens rea.
Can I ask you about your argument that the prosecution was delayed, which was your first argument?
Yeah, yes, Judge Wilkins.
Why, as I understand it, there's no indication that the government acted in bad faith. You agree with that?
So I don't agree with that, and I think where we probably need to start is the Supreme Court seminal decision in Lovasco, because the Supreme Court requires that the due process inquiry must consider the reasons for the delay as well as the prejudice to the accused. And we don't know the government's reasons for delay because the court made no findings about that.
What was the reason for the delay here?
That's the question, Your Honor. We don't know. Usually what the government will say is we are conducting these investigations at these times. That's not here. And actually what the government said is this is a simple case that doesn't need any investigations. And the district court judge assumed that the government knew about this case in 2012. So if they knew about the case in 2012, why did they wait until 2021, a month before the expiration of statute of limitations? We don't know. That's error. The court has to consider the reasons for the delay. We do not know.
What vitality does the due process analysis have in light of the presence of the statute of limitations? Isn't the setting, the question I was having was, doesn't the setting of the statute of limitations sort of subsume the due process argument and say that if this is within the statutory limitations period, that due process was observed? I mean,
Sure, Judge Wilkinson.
There's no question here that the statute of limitations was 10 years, and the prosecution was brought within 8 years or something, which is a very long delay. And I understand that prosecution should not be delayed that long. But on the other hand, I'm wondering if the formal statutory of limitations doesn't supersede the due process
Sure.
analysis, and whether that's really not, whether that's the ultimate measure.
Sure. I think that the statute of limitations is the outer framework. I totally understand that. But there's a reason why the Supreme Court decided Labasco. There's a reason why we look at pre-indictment delay, because in some circumstances, even if it falls within the statute of limitations, in some circumstances, it does violate due process. And this is the case
But
here.
what are the circumstances here that would lead to a due process violation given the statute of limitations? I don't understand.
Sure, Your Honor. So he lost, so first of all, I will say the government, the court should have looked into the reasons for delay. And we don't know the government's reason. And when the government waits until a month before the statute of limitations, they should realize that there could be evidence lost that would benefit the defendant. And that's what happened here. He lost vital testimony from his mother, who unfortunately passed away during that delay.
I understand that his mother died in the interim and before I thought that there were a number of other individuals that could have testified to his cognitive impairment, other than simply than his mother. That I understand there were multiple people who could have testified as to his cognitive impairment, which is, I think, a big part of your case on the mens rea point. Isn't that true, that there were other, that his mother was not, as important as that was, the mother's testimony was not the sole testimony going to that cognitive impairment point?
So her testimony was vital. And first of all, Mr. Palmer asked to have a hearing so he could tell the judge, present that to the judge. She was the only person that could provide that intimate kind of information about his mental health condition.
So can I ask you about that? So this is
Sure.
based on his assertion, Mr. Palmer's assertion, about what his mother would have said? That's it?
So it is his assertion, but that assertion is grounded in specific facts in the record. We know that he had a borderline intellectual functioning. He had an IQ of between 72 and 75. And we know from various documents in the record that after his mother died, he didn't have anyone else to write to. So his mother really did have that special role, and I think almost anyone can understand that a mother has a very special role.
His mother did have a special role, and that is true. Mothers invariably have a special role, but your opponents point out that her testimony was not relevant at the time of the offense, at the time that the false statements were made, that her testimony went to a different period of time than at the time the false statements were made, and therefore the prejudice, if such there was mitigated. Is that a fair point?
Well, actually, I would disagree with that, Judge Wilkinson, because his mother would have testified to his lifelong disability. He had it throughout his life. And she was the only person who could have testified to that lifelong mental health condition. And so it's very important, too, because the court wouldn't let Dr. Fahey testify that it was a lifelong condition. She wouldn't let, the court would not let Dr. Fahey testify that when he filled out the application, he was suffering from this disorder. But his mother could have built the bridge and let the jury understand that he was suffering from that mental illness at the time of the offense.
I thought his mother's testimony related to a period other than at the time the false statements were made.
Yeah, I believe if I'm understanding, his mother's testimony would have been to his lifelong developmental language disorder.
You're saying there was no variation? Saying there's no variation in terms of the cognitive impairment? That it was level throughout his life?
So the way that Dr. Fahey explained it is that this is an element that I understand was like from birth. It's developmental, and so it's so severe that his development did not exceed past the 4th grade level for reading and comprehension, and he wrote at the 2nd grade level.
Okay.
Thank you, Mr. Martin. Mr. Enright?
May it please the court. Anthony Enright for the United States.
Counselor, let me just ask you on that last point. I don't understand exactly why the government would need to wait 8 years before bringing this prosecution. That's a long period of time to leave somebody hanging. I mean, you know, the prospect of a criminal prosecution is something that is bound to trouble one's peace of mind and give one a considerable mental state of apprehension.
Sir-
And 8 years is a good bit of time. I realize the statute of limitations was 10 years, but why didn't you bring this earlier and let some resolution be had? Because, you know, you realize that until if people have the prospect of an indictment and a trial and investigations and all the sort of appurtenances that go along with the criminal justice process, and they're dealing with that apprehension for 8 years. Is there some reason that you waited that long?
Absolutely, Your Honor, and I want to correct the record because I think my friend said that we
What?
normally state, I want to correct the record because I think my friend said that we normally state when the investigation occurred and for some reason said we didn't in this case, but we did on page 89, page 123, page 191 of the joint appendix. We identified this crime through an operation that began in 2019, as we told the district court, without any dispute.
Well, you
called
answer my question. Why did it take this long to bring this prosecution?
We didn't piece together that he had made false statements on this form and that he had committed the crime beforehand until Operation False Haven went and looked for people who had done so beginning in 2019.
Well, you had the statements that he made to the immigration officers and everything. You had those for a good long time.
Yes, and he told us that he had not committed any crimes for which he had not been arrested.
How long would it take to investigate the falsity of the statements?
Somebody would need to put together the idea that
Don't
we
you
need
have-
to look.
Don't you have the record of what his past criminal history was?
Not until afterward, Your Honor, because what happened was he committed the crime. He then applied for naturalization, falsely stated he had never committed a crime before, and he was later
Well,
arrested.
can't you find the answer to that pretty quickly as to whether he committed or didn't commit a crime?
If someone has the thought to look for it, and the reason nobody thought to look for it was because he put on his form, I've never committed a crime. And then we asked him we did further investigate that form because he had sat for a naturalization interview. And the immigration services asked him, is that true? Have you committed a crime for which you've not been arrested? You answered no, is that true? He said, no, that's true. So if he wanted us to find out, he could have told us right then and there.
I mean, this wasn't a conviction, right? It wasn't
It wasn't a conviction until several years later.
unless the government is going to be required to investigate every statement for every representation that an immigrant is going to make. I mean, that seems patently unreasonable.
No, Your Honor, and I think most people would think it would not consider it prejudicial that we're not fly-specking somebody's statement that goes on a form against every single encounter with law enforcement. This was a state prosecution and a state conviction. This wasn't even in the jurisdiction of any United States officer. My friend did file something that shows that there was an FBI background check conducted, but that background check didn't reveal either the either the crime or the naturalization application. So there was really nothing there. Also, Your Honor, there is a case, United States versus Villa, we cited, which says that when you're talking about the measure is when the prosecution, which in that case was the assistant U.S. attorney and the agent assisting them in that prosecution, has probable cause to indict. That didn't occur until at the very latest, 2019 or 2020 or 21, after the defendant's mother has died.
So just as a routine matter, does the government generally accept the representations on these forms at face value?
The immigration officer actually testified to that. They conduct a.
But no, I wonder, is the way these things work, just trying to get to what happens in the field. Does the government have a statement and accepts it at face value unless evidence comes to its attention that there was something incorrect?
I think there would generally need to be, that's generally correct, Your Honor. The immigration officer who conducted the interview with him explained that.
You would accept it at face value unless information came to you that was incorrect?
Yes, that generally would. I think he testified that they don't conduct some type of a check just because somebody answers the form incorrectly. They do rely on the applicant being truthful and accurate, which is why it's sworn under penalty of perjury, and that's a very important thing. And you have to take an oath at your naturalization ceremony. It's not something that is just, we're trying to trick you. We rely on you to be truthful when you're making a statement seeking naturalization. I also want to emphasize that this standard, the statute of limitations, as I think Your Honor alluded to, even the Supreme Court said, that's the primary safeguard, even against losing evidence over time. And for there to be a constitutional obligation on us, there has to be, this is a big thing. We're going to dismiss the indictment before you even get to present your burden of proof. You can't prosecute him. For that to happen, there has to be some culpability on the part of the United States, and the language is, with respect to circumstances suggesting that the delay would impair the ability to mount an effective defense. So the question isn't, should we have initiated this operation as a policy matter earlier? The question is, were there any facts we knew or should have known?
Well, there's no indication, there's no indication here that you acted in bad faith.
Exactly, Your Honor. And in order for there to be bad faith, we would have had to really know that there's a serious risk that he's going to lose his mother and that his mother has exculpatory evidence.
The statute of limitations is the key element here. but
Absolutely, Your Honor.
It doesn't completely preclude any any due process analysis if evidence comes that the government acted in bad faith.
Yes.
Or if you delayed the prosecution for strategic reasons that a key witness for the defense was in ill health and you wanted that witness to die before the time of the trial or whatever, that would be evidence of bad faith.
Exactly. That's what I think the standard gets at. It gets at gamesmanship or maybe recklessness or negligence, but there has to be some.
That's not present here.
Exactly, Your Honor. Exactly. I don't think there's any reason, there's any plausible allegation anyone could make that we were trying to do something related to his mother.
The only point I was trying to make is that the statute of limitations doesn't preclude inquiry into the government's good faith or bad faith. It doesn't preclude a due process analysis if evidence of bad faith were to emerge.
That's correct, Your Honor. I mean, certainly if there's an effort to delay specifically to disadvantage the defendant in a significant way, that's going to be a real problem for
There are
us.
all sorts of strategic reasons one can have to want to delay an indictment or want to delay a trial or what have you.
Yeah, and I will point out, in the absence of something like that, time is the enemy of the prosecutor. We have the burden of proof, and it's a heavy one, beyond a reasonable doubt, at trial. So if we don't have any reason to think we're going to gain an advantage, it's not helpful to us to wait. What the court's cases talk about, the dissipation of evidence, the failure of memories, the death of witnesses, hurts us.
It's a fair point. You don't want to go forward with a half-baked case.
Yeah, and it bakes less as time moves on to use that analogy. I do want to talk about the court's Rule 704B ruling. What Diaz holds is an expert can't testify that the defendant was part of a group of people that all have a particular mental state that falls short of what the crime requires. And when Dr. Fahey was going to say he's at a grade 4 level and the question is a grade 8 level, a jury could easily take it as exactly that. He's in this group and it's short of the group necessary to knowingly answer the question falsely.
But the answers to those questions on their own are the kinds of things that are not, that's not junk science. People routinely talk about individuals reading grade levels. It's not, I mean, she didn't ultimately say, and then because of that, he didn't have the mens rea to commit the crime. I think that.
She planned to say that, Your Honor.
Well,
That was
yes, she was stopped at that point. Right?
Yes, and that's fair, Your Honor. Honestly, there's not an inference here because it's not most people who read at this 4th grade level can't read at the 8th grade level, but some can. She left it at that, and I think there's some room for the court to say, the district court to say, you know, there's a good chance the jury's going to take it like that. That the jury's going to take it as just, look, if I accept that, he's grade 4, the thing's at grade 8. If I just credit that, there's no inference to draw. He can't possibly understand the question. And there's room under 703 for the court to say, that's going to be confusing to the jury, and I'm not going to let it in. So it doesn't necessarily, there can be a way to interpret it where there's an inference, although frankly, I don't know that I don't see it. But that wouldn't establish an abuse of discretion by the court. But I do want to emphasize that the evidence that did come in was, as Your Honor mentioned, he performed poorly to very poor across 8 domains. That's what Dr. Fahey testified. So there was ample evidence from the defense side that an expert has evaluated him and said his reading comprehension is very, very poor here. And on the flip side, there's a lot of evidence from us that he could understand this basic question, including that the court, you know, as I think Your Honor alluded to, a jury can look at that question and decide for itself whether it's unusually complex. And the jury.
I remember when I went to baby judge school, I heard from a very seasoned district judge and a very wise appellate judge. And they both said, when in doubt, let it in. When in doubt, let it in. You know, you've probably run a little bit greater risk with the exclusion than you do with just letting it go.
I think that's correct, Your Honor.
That's a good rule of thumb, isn't it?
Yes, Your Honor. I'm an appellate attorney, so that's my rule too. I'm like, hey, you let it in, then we don't have anything to argue about. But I also understand that it's important to.
But, you know, sometimes you're not, you know, I said, when in doubt, let it in, and sometimes you're not in doubt.
And that I think is an issue here. Honestly, we objected to this evidence on many different grounds, and that is one the district court focused on, and so didn't get the chance to look at some others. And it's particularly rare that I would ask the court to say, you know, affirm on grounds of 702, which is really a district court's discretionary thing. But in this case, the expert, that creates an alternative ground for this court to affirm too, because in this case, the expert actually said, the methodology I used wouldn't be helpful.
The whole crux of the case revolved around the question of mens rea.
Yes.
And revolved around the question of whether he had the cognitive ability to understand the question.
Yes, and the jury heard a lot of evidence on that.
And the expert's testimony was that all such and such lacked the cognizability for that, which sort of adopted the defense conclusion of the case. The conclusive argument was that he could not have understood the question. And the expert testimony is saying because all people would, fourth graders or whatever, all people in his situation would never have understood this. There was no room left for the possibility that someone in his circumstances might have understood it very well.
That's
So-
exactly how I think the court was concerned the jury would take it. And candidly, that's how the defendant presented it. In her notice, she wrote exactly that syllogism. She's at 8th grade. His reading fluency and comprehension is at grade 4. The readability of the question 15 is at grade 8. That disparity led to the opinion that Palmer's not able to understand question 15. It's not an inference, it's just a logical syllogism. If he's at 4 and he needs to be at 8, he doesn't have the mens rea. Obviously, it's not the exact language of the statute, but
Well, it's an evidentiary question, and it's probably something of a judgment call as well.
absolutely. But I also, the evidence the jury heard included that he told a state court he could read and write at the 11th grade level. He completed a writing test and a reading test and a civics test to get the citizenship. And he orally answered the question, so even if his reading comprehension was poor, it was spoken to him. He read and wrote books for pleasure routinely. I think he said he read a book a month, westerns, love stories. He wrote tons of handwritten letters, and his ex-wife testified that he engaged in these social interactions and spoke to big groups and didn't have any problems. And he heard from Dr. Fahey that he had serious reading deficiencies.
What are your
So-
thoughts on the Padilla issue?
I think it's a question that really is I think the district court got it right when it said it was in the wrong forum. You can't collaterally attack a prior conviction for the first time in a state criminal conviction in a federal criminal case, except on one ground, and that's the complete denial of counsel. And the Supreme Court explicitly rejected the idea that extends to ineffective assistance of counsel, not once, but 3 times.
The Custis decision is United States versus Custis.
Yes, Your Honor.
Is right on point
I agree.
on that issue, and it says we're not going to have collateral attacks on state convictions in federal criminal trials.
Correct. You can take it to state court, you can take it in a federal habeas.
That there's a way for undoing these convictions, and that is to raise your ineffective assistance claim in a habeas proceeding,
Yes, Your Honor.
where the sole focus is on that, and if you try to attack these convictions in federal criminal trial, you can get that awkward position of having a trial within a trial, and something that's complete. You have to have a habeas proceeding during the course of the trial, and then you have a trial within a trial. As the Supreme Court said this, and I think it was Custis and Daniels and 2 or 3 decisions
Yeah.
that say, no, this would complicate federal trials significantly.
Yes, Your Honor, there's no unfairness, because we know in North Carolina specifically, they have a very, I think it has a very long statute of limitations, a very robust post-conviction process, and even if there's a problem with it, you can take it to federal court. So he was open, and it's been, many years past, as we discussed, he had plenty of opportunity to take his conviction to state court and challenge it. He chose not to do that.
Well,
I
he can
suspect
challenge
because
it,
it's
he
a
can
very good.
challenge it in a federal habeas proceeding.
Absolutely.
He's got a federal claim.
Absolutely. All those avenues were open to him, and what was not open to him was to challenge it in his federal trial and to ask the district court to exclude this plea, which the rules of evidence permit, on that basis. I have very little time left, but if this court has no further questions, I'll yield the balance of it back to the court.
Thank you very much.
Thank you, Your Honor.
Just a couple of thoughts, Your Honors, and then I'll have some closing remarks, and then I'll be finished. But I do want to highlight that the district court operated under a misunderstanding of the law when it refused to allow Dr. Fahey to testify about grade levels. I'm asking the court to please look at Rule 704, because grade levels, it's not mens rea. Grade levels are not an element of the crime charged. It just isn't. So the court's finding was erroneous under Rule
Why wouldn't it be a
704.
question of mens rea? It's a question of whether he knowingly made false statements.
Exactly, Your Honor. So that's the element. That's the element that the jury makes that final inferential link,
But why-
is the mens rea, knowingly
Why
lying.
wouldn't it be within the discretion of the district judge to say, no, this just flat out announces what your verdict should be, and, you know, that's the jury's job.
I think what we're saying is the court's finding under 704 was wrong,
I mean,
because the plain
expert
text allows the
expert
testimony.
was very flat and conclusive, and it didn't leave much, the proposed testimony didn't leave much room for doubt. He said, no, this is true in all cases. And it seemed a very unnuanced and a very flat conclusion. It left no room for questions or doubt or anything. And district court.
So if I could respond to that, Dr. Fahey wasn't going to testify that he had mens rea, that all fourth graders could not understand question 15. She wasn't giving that conclusive testimony. She was just giving testimony about the grade level of his language disorder and the grade level that he wrote at. That's not mens rea evidence. And so
Well,
the court's...
even if we accept that, okay, Dr. Palmer should be able to testify he reads at a fourth grade level, because that's not an ultimate issue. You can testify that question 15 is written at an eighth grade level. That, again, is not about the defendant. Cannot testify as to whether he understood 15, because that's the ultimate issue. All of that, even if there's error on that part, why is it not harmless? I mean, given the information that the government presented at trial, why it was significant as that he did in fact understand 15. Why is that not harmless?
So, Your Honor, it's not harmless because her evidence about grade levels undercut every single piece of evidence that the government relied on to establish mens rea. Look at the government's closing. What did they argue? Grade levels, that he reported an 11th grade reading level on a form. If Dr. Fahey would have been able to testify about grade levels, I think anyone would be able to understand, like, I know people who made it to the 11th grade, but they don't read very well, you know, but the jury wasn't able to hear that evidence, and Mr. Palmer had a right to present it under Rule 704 and under the rules of evidence. So that's our argument there. I would like to highlight a question that Judge Wilkinson asked earlier that I really liked. It was like, that's a long time to leave someone hanging. Great question. And what I present to the court is the district court judge should have asked that question at a hearing. And the government testified to...
Can I ask about that? So maybe I'm misunderstanding the facts. So the question
Sure.
was addressed to your client was whether or not he had ever committed a crime for which he had not been arrested, right?
Yes.
And he answered no. And at the time, at least according to the government, that was wrong because he had committed these offenses that ultimately he was convicted of, I think, a couple of years later, or when did that happen?
So the timing is very important because that state conviction was in 2013. And I think it's really important to understand the timeline because the 2013 case...
Well, before you get to that,
Yes.
at the time that your client answered that question, Mr. Endelin says, in most instances, you take that answer at face value. I suppose that even if they had run, maybe they did, a background check, I assume they did, they would not have found any convictions, right? Because he had not been convicted when he answered, at the time he answered the question. So what are they supposed to be looking for?
So I think what's really important is the court did say that they assumed that the government knew about that state charge in 2013. So that's important.
What is that assumption based on?
We don't know. The court didn't hold a hearing. But he made that, the district court judge made that statement that they knew about the court assumed that they knew about that state case in 2013. And so the question is, why did they wait so long if they knew in 2013? And I think these are questions that should have been looked into at a hearing. And it seems a little odd that the appeals judges are asking these questions because this really should have been settled at a hearing by the district court judge. We don't know there are so many things we don't know in this case. And I think what's very problematic, the government mentions the operation, but the government, from my understanding, has not said the investigations they were doing. From 2013 to 2021, what investigations were they doing? And under Lovasco, the court has to determine the government's reasons for delay. We just don't have that. What is the reasons for their delay? We don't know. So it needs to go back to the district court for that. And I'm sorry.
Did you press for a hearing on this point?
We did, Judge Wilkinson. We asked for a hearing. We cited his due process rights. We get told specific information about his mother, that she was the only witness available, and we asked to present more evidence about it, and we didn't get a hearing. And so now we have all these questions because the judge never made any findings as to the reason for delay, and the judge needs to do that under Lovasco. It's black letter law. And I have just, if I could, just a very quick closing thoughts, and then I'll be.
Go ahead.
Thank you, Your Honor. In closing, as a public defender, it's an honor and privilege to tell my clients' stories. Attorneys Aaron Taylor and Myra Cause represented Mr. Palmer at trial, and Ms. Cause is here today in court to show her support. Ms. Taylor and Ms. Cause are brilliant attorneys who zealously fought to defend Mr. Palmer's constitutional rights, but they weren't able to tell his whole story due to the court's evidentiary errors and failing to hold a hearing that he should have held. A couple quotes. Martin Luther King Jr. stated, "We are tied together in a single garment of destiny, caught in an inescapable network of mutuality." Judge Gregory referenced this quote in Nathaniel Black's case, stating, "Our individual freedom is inextricably bound to the freedom of others." When I think about these quotes, I think about Mr. Palmer's case. When any defendant is denied core protections under the Due Process Clause, it affects all of us. Mr. Palmer should be able to tell his full story, and we respectfully request the court vacate his conviction. Thank you.
All right, thank you, Mr. Martin. Thank both counsel for their fine arguments here today. We'll come down and greet you and move on to our final case. 513, United States versus Hudak. You can correct me if that's wrong. Mr. Lester?
May it please the court, Your Honor. My name is Gene Lester, and I represent Marion Hudak. The issue in this case is whether the jury should have been allowed to consider evidence of Mr. Hudak's mental health diagnosis and symptoms to disprove the specific intent element of the offense, here racial animus. Mr. Hudak was charged with 2 so-called hate crimes, and one of the elements of the hate crime is that he committed the acts with racial animus. That was the specific intent element that we contested in this case. And we wish to show evidence of Mr. Hudak's mental status in order to show that his behavior could have been, or the jury could make a reasonable inference that his behavior was not because of racial animus. The evidence that was the rule we think that is controlling in this case is from Worrell. And in Worrell, this court has held that psychiatric evidence of a defendant's mental condition is allowed when such evidence is offered to rebut the government's evidence of specific intent. Here, the evidence that was not allowed was of his mental health diagnosis and symptoms. And that evidence could have been offered or could have been testified by Mr. Hudak himself at trial, and that was denied, as well as through the expert testimony of Dr. Graney. Her testimony could have been allowed, and it was denied. And what the evidence would have showed was that during the period of the offense conduct, Mr. Hudak suffered from chronic mental health illnesses. And those illnesses included obsessive compulsive disorder, a aggravated form of generalized anxiety disorder, and paranoid delusions. And those mental illnesses resulted in symptoms that he felt fear about being followed, fear about being spied on.
Does it matter here that the defendant did not offer an insanity defense?
No, Your Honor. He did not offer an insanity defense.
Wouldn't that have made the, what is it, Graney's expert report more relevant?
Your Honor, we believe that Mr. Hudak was competent to stand trial, and that he was not insane, and that he had ability to control himself, but that an explanation for this conduct was that he suffered from these conditions. In fact,
But the district court looked at the report and said it's not relevant because it covered a state of mind that was 1 year after the JS offense and 2 years after the JD.
right,
And that there wasn't anything in the report that addressed the question of what his mental state was during the time of the actual conduct.
right. Well, we just,
You know, somebody's mental state, I suppose, can change rather dramatically within a year or 2 years.
yes. We disagree with the district court's interpretation of Dr. Graney's proposed testimony.
Why didn't Mr. Graney's report address the mental health, the situation of mental health at the time of the offense rather than several years later?
Right. So Dr. Graney was an expert who was retained by previous counsel to determine whether he was competent to testify. And Dr. Graney's report concluded that he was competent to testify. And that report was published about October 31st. And I was appointed in the case in November. And having read the report and looked at the contents of the report, not necessarily her conclusions.
It was an odd sort of report, wasn't it? I mean, this man made death threats and everything, and the report called them insults. Well, I mean, you know, insults are no big deal. I mean, sticks and stones break my bones, but words will never hurt me. That's insult. But then, you know, you ratchet it up to what the defendant was doing, and he was issuing death threats. And that's not just an insult. That goes so far beyond being an insult. And that's what the report kept calling them.
Well, there's no doubt that we conceded at trial that Mr. Hudak had the specific intent to make threats, that he had the specific intent to perform and do the conduct, the bad conduct. But the difference here is that that this offense required it to be proven by the government specifically that he did it for purposes of racial animus. And what we wished to do was present not only Dr. Graney's expert testimony, which was denied, but also his testimony that he suffered from these mental conditions that caused him to have fear about being followed or spied upon, being stalked, repeatedly engaged in behaviors like looking out his windows, and to have a difficulty regulating his emotion and difficulty with ambiguous situations, that he tended to see things more threatening than they might be, that he had angry outbursts and
just
rage
in
out.
terms of the intent here and question of because of in the statute and whether, wasn't there a lot of evidence that this individual, Mr. Hudak, became enraged by the simple fact that it was a black man who he thought was blocking his way, and it was that fact that just completely set him off. And isn't that about as clear an example as of a racist crime and a racist act as one could expect? I mean, if that doesn't qualify as a racist motivation, then I don't know exactly what would.
Well, I think the government had ample opportunity to demonstrate that there was racial animus here. And what we were asking to do was to allow expert testimony or non-expert testimony in the form of mental health to demonstrate that there was another explanation for the purpose, the goal here.
But he flipped out over the race of the individual whom he thought was blocking his way. If that had been a white person who was blocking his way, he would have been able to maybe think no big deal, but he flipped out over the race of the individual, and that's the kind of behavior that the statute is aimed at.
That's correct. And the question here is, why did he flip out? Why did he flip out when he was confronted on the highway with a loud vehicle? Why did he flip out and become enraged when a neighbor revved his car to a high degree? Now, one of the reasons for that is because he harbored racial animus against these individuals and didn't like the way they presented themselves because of their race or national origin. And that would have been enough to convict him. But another possible inference, and the one that we were allowed to present, is that he suffers from serious mental health conditions that are consistent with these behaviors. And therefore, he has delusions in his head, he has fears, he believes that things are more serious than they are, he misjudges.
To something Judge Wilkerson alluded to earlier, these offenses occurred between November 2021 and October 2022.
Right.
The report details incidents that are far earlier than that, and even goes so far as to say, well, he's doing fairly well by November of 2016. He has a small setback. He's drinking somewhere around 22, I guess, but that's related most to this fear of washing his hands excessively, OCD. And so it doesn't seem to match up as to an expert's testimony that's going directly to his mental state, even if it is admissible, during the period of time he committed offenses.
Your Honor, the purpose of the report was to determine whether he was capable or he was competent at the time of trial. And so her conclusions are that he is competent at the time of trial, and some of these conditions are in remission. But what she says in the report, and what she says at sentencing, which the court can consider as a proffer of her testimony here, is that these are chronic conditions that may be in remission. And specifically, there are 3 conditions that she says were active. One was the OCD, the other was the anxiety disorder, and the other one the delusions. And she said those are in remission because he's been in jail, essentially. And some of the stimuli and some of the alcohol and some of the other problems are less prevalent because at the time of the report, he had been in prison. But he had suffered from all of these conditions since either 06, 011, or more recently. And what she would testify to was that the behavior was present during the offense conduct in 2021 and October of 2022.
How does the mental report, in your view, at least the mental health impact, indicate that he acted in part for something other than his race?
Right. So I think that's a question for the jury to determine. And here, what we wanted to do was to present evidence that when someone is delusional and has outstretched fears for what would be normal, they may act
None
out.
of which you
and they
have
may be-
expert testimony indication that occurred during a period of time that these offenses occurred. Everything you just said,
Yeah.
delusional and all of that, there's nothing in that report that says he suffered from that, other than an inference or maybe a speculation that this was going on the whole time.
Right. So what she would testify to is that he suffered from these chronic conditions, and these chronic conditions were consistent with his offense conduct, and that these chronic conditions existed during the offense conduct. And therefore, somebody who has these conditions would act out in this way. And
That's not in a report, though.
Well, I think it is in the report. What's not in the report are the conclusions. What's in the report are conclusions that have to do with his competency at the time of trial. And also, Your Honor, we also asked to present this evidence through Mr. Hudak, and we were not allowed. And so it wasn't just the report. We think that the judge made an error of law in disqualifying this evidence completely.
Did I understand the basis for introducing this evidence to be Rule 404B? That seems to be an odd fit.
Yeah, so I think that, and the more I think about this, Your Honor, I think perhaps the first threshold issue is whether the court committed an error of law in categorically saying the mental health testimony in this instance to negate a specific intent crime was not admissible. And I think that's an error of law.
Under what rule?
Under the Worrell case. And then I think that the court erred in not applying Rules 401, Rules 403, and finding that it's probative, that it's relevant. And then I think the court erred in its judgment that it would not have assisted the trier of fact under Rule 704 or 703 to assist it in determining whether or not he had the specific intent of racial animus.
Was this evidence introduced to show that it was a contributing factor to the attacks? That his mental health was a contributing factor to it?
It would have been introduced to negate the specific intent element of racial animus. And
But
that's,
was it introduced to show that at least it was a contributing factor to the attacks?
yes, it could show that somebody with these conditions is motivated by things going on with obsessiveness, things going on in their heads, fear of people looking at them or watching them. Because if you look at the offense conduct, he gets involved in altercations with people over fairly minor incidences. He says, with respect to the incident on the highway, he says, there's too much noise on the road. I'm going to get out of my car and confront this person. There's too much lights coming into my windows. I'm going to get out of my house and confront this person.
But isn't that the kind of diminished capacity defense that Worrell prohibits?
I don't think so, Your Honor. I think that Worrell does not allow, Your Honor, I see my time is up. May I
No, you
finish?
can answer.
That it doesn't allow you to say that he lacked the control to do those things. It's just, why did he do those things? So the purpose of what we're asking is why? And this is only a crime if he did it because the person was black and Hispanic. It's not a crime if he did it because he has serious mental health issues for which he's manifesting.
So that, you know, our country is being badly frayed by these extremist acts of violence. And a lot of the extremist acts, they're motivated by various delusional and states of mind. But it does seem to me that racism is an element in many of the extreme acts that are perpetrated. And Congress responded with these statutes, which was designed to track racial motivations. And in all of these cases, there's some mental health defense that's interposed. But that's just way too broad a business to, direct a verdict or take something out of the jury's hands. Because obviously there's a mental health disturbance that's led to this kind of vile behavior. People who are balanced in their outlook and perspective on life do not go about acting in this sort of way. And so there's always going to be, it was my mental health. I was mentally unhealthy. Well, all of these people that commit these horrible, horrible acts are mentally compromised. They're mentally unhealthy. But that doesn't mean, in some way that these things are excused, or that they should not be held culpable to a significant extent. And that's what we have before us here. He said, I was I wasn't in good mental health. Well, so what? It's a jury question. And if we buy onto this whole idea of mental health as an excuse, we're simply apologizing for acts that are tearing the country apart. And so I'm not sympathetic to this particular issue. And as far as your defense, this Nazi propaganda was just being, because he was purely a collector. This was with respect to the J.D. offense. Well, he can collect this filth as he wants, and he can display this filth out of his window, I suppose, and everything, but it's still relevant to why he was acting in the way that he was with J.D., which I guess he thought was consistent with some kind of Nazi propaganda about some kind of horrific and wholly evil idea of racial superiority. And this is what this person seems to have been driven by from the get-go. And it shouldn't be, there's no way that the jury should be required to countenance what happened here. What happened here is all too emblematic. It's happening too many places, to too many people. You see racial animus, religious animus, ethnic animus. You know, no way is that a path forward for this country. And I'm not sympathetic with this in one little bit. He had a right to a jury trial, and I understand that. He was given a jury trial by a very capable district judge who made one 403 ruling. It seemed perfectly defensible to me, and then another 404B ruling. If this went to this individual's intent, seemed perfectly defensible to me. I'm all for giving him a jury trial, but jury came down hard on this. They expressed the community spirit that this is not who we are. And, you know, it's not my office to overturn what I think were the jury's good instincts. I'd let it stand.
Judge Diaz, may I briefly respond?
Good luck.
I agree with much of your sentiment, Judge Wilkinson, and I only very narrowly suggest that the law is broad enough to allow that mental health evidence be used to is not used to justify or excuse the criminal conduct, but it can merely be an aid to a jury in determining the defendant's state of mind with respect to the specific actions they took or committed. And so the question for the jury was whether racial animus was the motivating factor. And some evidence of that, or some potentially helpful evidence to the defendant, was his mental state, and that wasn't allowed. But I have no problem with the jury deciding the case on the issue of racial animus, given the narrow purpose of allowing that mental health evidence.
All right, thank you, Mr. Lester. Mr. Levine?
Good morning, Your Honors, and may it please the Court, Brant Levine for the United States. The district court here committed no abuse of discretion in its evidentiary rulings. And I'd like to begin with the mental health evidence, specifically Dr. Granley's report. The district court issued a thorough and well-reasoned opinion holding that Dr. Granley's expert testimony is barred under Rule 702 because it would be irrelevant and unreliable. In Hudak's opening appellate brief, Hudak does not allege any error, much less an abuse of discretion in that decision. There is no challenge whatsoever to that ruling. Instead, Hudak claims that the district court should have looked at this under Rule 404B. But Rule 404B is not some magic talisman that can transform inadmissible evidence into admissible evidence. Once evidence is inadmissible under a federal rule or statute, that ends the matter. Rule 404B has no role to play, and Hudak abandoned any other challenge to the expert testimony. Now, in Hudak's reply brief, Hudak raises a new argument for the first time, and putting aside that that's improper, I'd like to address that, and that is under the Insanity Defense Reform Act, that the evidence would be admitted to negate specific intent. One thing that we do agree with Hudak on is that this court's decision in United States versus Worrell controls, but we have a very different reading of that decision. What that decision says is that a defendant is prohibited from arguing that a psychiatric condition compelled him to act, that a psychiatric condition prevented the defendant from engaging in normal reflection before acting. That is exactly Mr. Hudak's defense here. And again, on page 7 of Hudak's opening brief, he says that he wanted to introduce this evidence to show that his conduct arose from his mental health struggles. And that is precisely the type of evidence that is prohibited under the Insanity Defense Reform Act, as this court emphasized in Worrell. Now, in Worrell, this court did recognize that there might be a rare case where you can use mental health evidence to negate specific intent. But when this court was talking about specific intent, it's talking about mens rea. And here, Hudak conceded at trial that he had the mens rea to commit this offense. On Joint Appendix page 109, Mr. Lester said to the court on the hearing on this issue, quote, "We're actually agreeing that he has the willful mens rea to do these things," end quote. That ends the matter. Anything else is going to why. And one thing, too, Mr. Lester said, and it's in the briefs, that the government was required to prove racial animus. That is not correct. Racial animus is not an element of this crime. What the element of the crime under the plain text of the statute is that we have to prove that the defendant acted because of the race or color of the victim. And I'd like to just briefly quote from the jury instructions here, the uncontested jury instructions, because I think that really highlights the issue here to show that there was no error. The jury instructions say, quote, "A person may have multiple reasons for his actions, and you need not find that the defendant acted as he did solely or even primarily because of JS's race or color. In fact, you may find that JS's race or color had only a slight or incremental effect on the defendant's actions toward JS, as long as you find that the defendant would not have acted as he did in the absence of JS's race or color," end quote. So right there, Your Honor, that encapsulates the well-reasoned axiom that defendants often have multiple reasons for committing crimes. Here, both things can be true. Maybe Hudak would not have committed this offense but for his mental health, but it can also be true that he would not have committed this offense but for the race or color of the victims here.
And how's that statement different from racial animus? What's the difference, the daylight that you see between those?
The daylight between those, the essence of Hudak's defense, if I understand it right, he's not necessarily disputing that he targeted people because they had black or brown skin. What he seems to be saying is, look, I don't hate black or brown people. I did this because I have these mental health conditions. So there's a very little bit of daylight there, but we don't have to prove racial animus. That would make it extraordinarily difficult in hate crimes cases for the government to prove this, because oftentimes defendants will say, look, I don't hate black people, I don't hate gay people, and we don't have to prove that there was actual hate. We just have to prove that the defendant would not have committed the crime had the victim been, say, white instead of black. And here there's overwhelming evidence in the record, as I think the judges have noted, that the defendant would not have committed these crimes against white people. There's evidence that he used the N-word multiple times against the black victim. His Mexican neighbors, he used vulgar terms to reference that they should go back to their country. So there's a lot of evidence in this case. If this court wanted to even rule on harmless error, that would be another basis, because there is such overwhelming evidence of guilt. If the court doesn't have any other questions on the mental health issues, I'll briefly address the Nazi paraphernalia. Turning to the Nazi paraphernalia, as Judge Wilkinson noted, it is highly relevant in this case, but I think there's an even easier way for this court to resolve that issue, and that is Hudak opened the door. The first time the jury heard anything about Nazi paraphernalia was from Hudak himself, when his counsel was asking him where he got a racist pamphlet that used the N-word and depicted violence against black people. Hudak said, "I got this from somebody at a gas station, and he gave me KKK flags and Nazi flags." Right there.
He kept saying he was a collector. Well, as I've pointed out, if he wants to collect this filth, it's up to him. He can collect it, but the evidentiary question is whether it's relevant to the reason that he committed the offense. And it seems to me, if your home environment is saturated with Nazi paraphernalia, that bears rather acutely on the motivation for the offense. So the district court let it in. Nothing wrong with that.
We agree with that, Your Honor. People who display Nazi flags do not limit their hate to Jewish people. The Nazi flag and the swastikas are universal symbols of hate. And as far as whether he was a collector or not, that goes to the weight of the evidence, and the jury couldn't decide that. That maybe this isn't a symbol of hate, maybe he was just a collector, that's for the jury to decide, and the jury did decide that here. If there are no further questions, we would ask this court to affirm the convictions. Thank you.
Thank you very much.
Your Honors, I would concede that the judge unlikely committed any error with respect to the not allowing the Nazi memorabilia or the Nazi relics or other evidence of racial intent. What he didn't do was allow the defendant to put on some evidence to negate the specific intent. While the government was allowed to present these things that exist in the world and then link them to his mental state, he was unable to present credible evidence of that his medical condition likely was a motivation for some of the conduct that he exhibited. And it was up to the jury to decide. And you talk about...
Well, but before you get to that, you had to, and Judge Wynn, I think, may have asked you about this. I'll ask you to reemphasize the point. So we've got Worrell, which generally bars this kind of evidence. And what's the exception that you're relying on?
The exception is stated in Worrell. And it says, as long as it goes to negate the specific intent, and it's not showing a lack of volitional control. And what Judge Graney says is that he had full capacity to not only understand and be tried, but he also had full capacity to either commit these acts or not. But what she was saying, and what we would have presented to the court, to the jury, was that when someone is hearing things and someone is thinking a certain way and someone has anger issues, they're likely to act out. And then we would tell the jury, regardless of what the race of the person was, that these are triggers that happen. Now, racial animus can be shown through racial slurs, but that also cuts two ways. It can be intimidating, which we don't disagree that he had the intent to be intimidating, but it can also go to show that he had racial animus. So it cuts both ways. But we were unable to show, at least with respect to this evidence that Worrell should allow, categorically, in a limited basis. And we think that the judge could have offered a limiting instruction in saying, look, this, to Judge Wilkinson's point, this evidence does not excuse the conduct. It is not an affirmative defense of the conduct, but it may allow an explanation as to why he committed the conduct, separate and apart from racial animus, and that element alone.
As far as the evidence that he let in, I would
Yeah.
think that would go to, I thought it was a question of weight, not admissibility. It seemed a question of weight. And I wanted to, my lack of sympathy for this situation does not affect my feeling that he should have a jury trial and that he should have the best legal representation available. I'm sure the chief will express the court's appreciation, but it's a tough case for you and everything. And I really appreciate your taking it on. It's an unattractive, a very unattractive situation, and it's why I respect you for taking it on.
Thank you, Judge. We respectfully request that the court allow the evidence that was proffered either through Dr. Graney or through Mr. Hudak with respect to his mental health to negate the specific intent element and remand the case for retrial.
All right, thank you, Mr. Lester. Judge Wilkinson said it better than I, that we are indeed grateful and recognize that you're court appointed. I think you were the trial counsel as well.
That's correct.
So doubly grateful for your willingness to do this, particularly in these trying times when court-appointed lawyers are essentially working without pay, given the budget difficulties we're facing. So thank you for that. And Mr. Levine, thank you for your excellent representation of the United States in this matter. We'll come down and greet both of you and then adjourn this session of court.